I am
Yes.
praying for slight indulgence of this honorable court.
Yes.
There is a fixed item at item 61 in the orders column, Lordship. This matter was heard last week and it was fixed today.
Mhm.
Lordship, I have some personal difficulty today. I have to catch a flight at 2 o'clock. Could it be taken up before 12 o'clock, Lordship? If Lordship, I can inform the other side.
All right.
Highly object, Lordship.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item 50
Mhm.
today's course, daily list lordship. Lordship, we could not find a reply because the petitioners, they were living outside Assam at present, lordship. They could not come. One of them, we informed him, he could not come.
What do you want? What do you
Lordship,
want?
we want time, lordship.
How much time?
3 weeks minimum, lordship.
On the prayer of Mr. D. Das, learned counsel, appearing for the writ petitioners, this matter stands adjourned for 3 weeks, so as to enable him to file a
Affidavit in reply, lordship.
affidavit in reply, list accordingly. Yes.
I'm
Okay,
highly
please, Lordship. I beg to mention item number 5 of daily list. So, Lordship, the matter is infructuous. I may be allowed to withdraw this petition.
Sure.
Item number 5. Lordship.
Mr. N.H. Lashkar, our counsel for the petitioner seeks leave of this court to withdraw this late petition. This full step. Mr. Ardhar, learned counsel, learned government advocate Assam is present and does not have any objection. In view of the above, this writ petition stands disposed of on withdrawal.
May I please? I beg to mention for listing one matter, my
Hmm.
contempt petition.
Huh?
A contempt petition.
Second week of June, put any date, second week of June.
Second week of this.
May I please your lordship? Lordship, with the consent from the other side, I beg to mention item number 36 to 40.
Hmm.
2 weeks time may be granted to file affidavit in opposition, lordship.
36 to 40.
There is stay order, lordship.
You are appearing for whom?
I am appearing for the respondents on behalf of Mr. S.K. Methi, CGC.
You have informed the other side.
Yes, lordship.
You have informed.
Yes, lordship.
Otherwise, I'll take up the matter.
Okay, I have been.
Huh?
It is my senior have informed the other side
You
already.
please tell me clearly, have you informed the other side or
Yes,
not?
yes, lordship.
You have informed.
Yes.
But if they come and say it was not informed, then we'll finally take up the matter. Your name, please?
KK Methi.
Mr. KK Medhi, learned counsel appearing on behalf of Mr. SK Medhi, learned CGC. In all these writ petitions, seeks adjournment of admission hearing of these matters for 3 weeks. On the ground that the arguing counsel is out of station.
No,
Yes.
the affidavit in opposition, we have
On
not.
the ground
filed.
that affidavit in opposition has could not be filed in the matter till today. Full stop. Since the prayer is made with the consent of learned counsel appearing for the writ petitioners in this batch of writ petitions, same stands allowed. Affidavit, counter affidavit on behalf of the respondents be filed within 3 weeks from today. Let these matters be listed again after 4 weeks for
Obliged,
admission.
lordship.
Yes,
May I please, I beg to mention item number 18, Padma Pura Day Lordship. Actually, it is from medical,
18.
18, 1
Yes, you are for the petitioner.
of petitioner Lordship.
Yes, Mr. R.L. Chutia,
Lordship.
learned counsel for the petitioner, raised for adjournment in this case for 4 weeks. Prayer allowed, list accordingly.
May I please, your Lordship. Lordship, with regard to item number 61 of the daily list, my lord.
Hmm.
In the IA, we have filed affidavit in opposition today, my lord. It may be called for, my lord.
Yes,
Obliged.
May I please your lordship? Lordship, I beg to mention for item number 2 and 3. Both the matters were pursuing the learned counsel P. Soikia, but he is in now government panel.
no,
lordship.
we'll have to wait. These matters have been listed top of the list. These are 2019 matters for motion.
But,
After a long time, it has been listed on a specific instruction from the Honorable Chief Justice.
but
You wait, when the matter is called up, we'll see.
May I please your lordship, I beg to mention for listing the matter. Matter relates to selection and appointment.
Second week of June, we put any date.
Obliged.
Yes.
No, so may I please your lordship, I have beg to mention for listing an item. The
Third week of June.
yes.
You want to withdraw?
Yes, lordship, with a liberty. With a liberty to file it.
No, but have they filed counter affidavit? You filed affidavit?
No, lordship.
No objection?
Lordship, withdrawal, no objection, but lordship selection of 2009 lordship.
Not 2000, 2000.
2000 lordship.
How-
Selection process of
Why you want to
2000.
withdraw it?
I file a fresh, your lordship was on last of it, the lordship was asked me to file.
But maintainability, you asserted.
Regarding the.
Mr. T. Vaidya, learned counsel appearing for the writ petitioner seeks leave of this court to withdraw this writ petition with liberty to file afresh after rectifying the defects in the writ petition. Mr. S. S. Roy, learned government advocate Assam, submits that since the writ petition assails selection process conducted in the year 2020, he be granted
2002 lordship.
2002,
2000.
2000.
2000. Lord.
year 2000, he be granted leave to question the maintainability of the new fresh writ petition as and when the same is filed. In view of the above, by accepting the request of learned counsel for both the sides, this matter stands disposed of on withdrawal. File it.
For motion item 2 and 3.
This matter was last listed in January 2020. What is the matter about?
My lord, this is a transfer matter,
Hmm.
but this man has resigned. My information is resigned from the society, my lord. Basically, it infructuous. He should know it.
Infructuous, we'll close it.
My lord, is it the petitioner who should say, my lord? Because I have not got written instruction.
No, we will close it if the instruction is.
And otherwise also, transfer matter 3 years old past.
Take down Miss
Embora,
Miss M. Bora, learned counsel is present on behalf of, there are
Big
two writ
over.
petitions
on behalf of Big Gogoi Lordship.
on behalf of Mr. B.
2 is
Gogoi.
for transfer and 3 is he was not didn't receive salary for June 2019 onwards, few months or 1 or 2 months.
Which is the transfer, writ petition
First
number?
one, serial number 2.
You pass this order, you write this order in item 2. That so and so, learned counsel has appeared on behalf of Mr. B. Gogoi, learned counsel for the petitioner, Mr. M. Nath, learned senior
2 and 3,
counsel,
my lord. I am for.
assisted by Mr.
My lord, I'm for respondent number 1.
A. Bhattacharya has appeared
Yeah.
for respond numbers 2 and 3. Mr.
A Bhattacharya.
What is his?
A
your name?
Bhattacharya.
My lord, P. Handic for respondent number
Mr.
1.
P. Hendig, learned counsel is
PNRD.
present on their respond number 1. In this writ petition, a transfer order dated 7/9/2019 issued by the State Mission Director of Assam State Rural Livelihood Mission, transferring the petitioner has been put under challenge. Full stop. Record reveals that on 27/9/2019, on 18/9/2019, an interim order was passed suspending the operation of the impugned transfer order dated 7/9/2019. This matter was last listed on 07/01/2020, but thereafter, this is the first time the writ petition has, thereafter, this writ petition has been listed today. Mr. Nath submits that the writ petitioner has in the meantime resigned from the post of
From the post of assistant, MIS come assistant, it is called, my lord.
resigned from his post. Moreover, the transfer order
MIS
having
full
been
form,
issued
MIS full form. No, MIS. MIS.
more than 3 years back.
Yeah,
the
the
writ
MIS.
petition,
Every year there is an MIS.
3 years back, no cause of action survives for adjudication in this case. Full stop. Taking note of the submission of Mr. Nath, this writ petition stands disposed of as infructuous. Stay order passed earlier shall stand vacated. Where is the other writ petition? Let us see. Item 3. What is the issue here?
The petitioner didn't receive salary from June 2019 onwards. Few months, I think it was, my lord. But
Yes.
salary was paid, but without document, I, my lord, cannot say exactly. It came all of a sudden.
Take down HUD, so and so, same. Like, and everybody is same. The grievance of the petitioner is that he has not been paid his salary,
Appearing for PNRD.
area salary
He has not appearing
for the month of,
for rural Assam.
since the month of June 2019, till filing of the writ
Rural
petition.
Assam is to pay.
First of,
He's got nothing. to
Uh,
lose.
it appears from the record
Formal party.
that this writ petition was last posted on 25/10/2019. In view of the above, the learned departmental counsel to obtain instruction and appraise this court as to whether the salary, area salary of the petitioner has been paid in the meantime, and if not, the reason for not doing so. List this case again for motion on 26th of May 2023 as a fifth item. Yes. What is the matter?
Lordship, in this case, no extra, they are challenging one advertisement, Lordship, the advertisement was in the A file, Lordship, paper publication. They have not given any extra copies, Lord, they have filed IS.
It does not appears for the petitioner when the matter is called up. Mr. S.S. Roy, learned government advocate Assam, is present on behalf of the state. Full stop. This writ petition was last listed, these writ petitions.
One writ petition, Lordship,
which is
one
this-
writ.
This writ petition was last posted on 08/01/2020. Full stop. The challenge made in the writ petition is in respect of advertisement notice dated
9/8/2019. 9/8/2019.
9/8/2019, whereby whereby 5 posts of junior assistant was re-advertised. Full stop. Record reveals that although this matter came up for consideration before this court on 20/11/2019, yet no interim order was passed by the court. Full stop. Moreover, it appears that the petitioner's counsel has also not furnished copies of the writ petition to the learned government advocate Assam to obtain instruction in the matter. Full stop. Having regard to the facts and circumstances of the case and the relief prayed for in this writ petition, this court is of the opinion that no live issue survives for adjudication in this case at this distant point of time. The writ petition is therefore disposed of. The writ petition is therefore disposed of by holding the same as not maintainable in the eye of law. And the IS will stand disposed of accordingly.
Item 6.
My lord,
Yes, what is the instruction?
My lord, I am still waiting for the extra copies, my lord. We have drafted the letter. It's on the file, it's written no extra copies of till.
We have not furnished extra copies.
Furnished, my lord.
My lord, usually if we, the letters, my lord, it is all ready, my lord. Just when you get the thing, we send it.
We'll issue notice returnable in 6 weeks. Heard Mr. N. M. Agar, we are learned counsel for the writ petitioner. Also heard Mr. R. Dhar, learned government advocate Assam, appearing for respond numbers. Yeah, for what? PWD?
My lord, I will appear for all. My lord. Here.
Your colleague may not like this. You are appearing
Oh,
for
no,
whom?
no.
Why are you asking her?
No, my lord. My lord, when my lord asked that PWD, that's why I said I will appear.
Learned government advocate Assam appearing on behalf of the respond numbers 1,
114, my lord.
1 and 4 and Miss D. Neo. DS Neo.
235. 23.
For learned SC irrigation for respond numbers 2, 3 and 5. Full stop. The matter pertains to rejection of prayer by the SLC for appointment of on compassionate ground. The learned departmental counsel submits that due to want of extra copies of the writ petition, instructions, as called for, could not be obtained by them. In view of the above, the petitioner's counsel to furnish, in view of the above, issue notice of motion returnable in 6 weeks. Since the respondents are already represented, no formal notice be sent in this case. Extra copies of the writ petition be furnished to the learned department counsel so as to enable them to obtain instruction. What is this?
My
Somebody
lord,
else?
the matter relates to recruitment to the post of junior engineer in Public Works Department. Now, my lord, our matter has been possibly tagged with the first item number 7, which is a new matter. In our matter, my lord, notice of motion was issued and there is an interim order also. The issue is, my lord, whether civil engineering and planning are one and the same subject. Now, my lord, of the petitioner's grievance is, my lord, we applied for this particular post and in this screening test also we were cleared and we were about to appear in the later segments of the test. When at that stage, my lord, we were told that you are not qualified to participate in the selection process. That is the grievance. Now, state would like to say that civil engineering and planning are two different subjects. Whereas, my lord, All India Council for Technical Education says the major branch is civil, these are all sub-branch.
All right, how long will you take to argue the matter approximately?
About half an hour.
There is, I'm told there is someone has made a request for VC here.
Yes, my lord, Manas Burman appearing for item number 11.
Yes, these are all tag matters.
Actually, our matter has been tagged because at the request of the petitioner in item number 7. Otherwise, today our matter was not fixed. That is how the matter has come.
Actually, other matters are already, my lord, pleadings are exchanged, notice were issued, my lord, that should have come in, my lord, admission. But because, my lord, one order, one challenge was made before it's honorable, that is not declared. That was item number 7. In that case, my lord, we given a reply because there is some barrier in my lord, there is an obstruction, my lord, that these other petitioners, my lord. That's why all cases.
Right now, who's made a request for?
I think the, my lord, petitioner in item number 7, Mofidul Islam Khondokar.
7 is the
Petitioner.
that is petitioner, is a different case, my lord. It is a case for declining result.
No, the case for declaring result because there is an interim order
Yes,
operating in
that's
our case.
No, that interim order is not to, my lord, fill up the post, my lord. Already, my lord, there are 97 posts, my lord. There is an interim order delivering
All
97.
right, so what I'm asking is, these matters are to be taken up together.
No, actually, my lord, if there is a stay order operating which is coming in the way, ideally, my lord, what they should have done was file and stay vacating petition instead of filing a new writ petition. Anyway, since they have filed it, lordship can add it together.
All right. We'll hear it, but since there is a VC request, we'll to take it at the end of the list.
Or lordship can fix it on a
Another
Tuesday
day.
or a Thursday, my lord.
Because, yes, my lord.
Yes, what do you say? Who's appearing on VC? Who's there?
My lords, I'm Manas Burman appearing through Vice VC.
You are hardly.
Your voice is
audible.
not audible.
I'm sorry, my lords, I'm actually inside the court. There's a matter to be listed. Probably that's the reason, my lords.
But at any case,
We
my lord,
don't decline requests for VC, but these are matters.
Oh, yes, it will take some time, my lord. Yes,
These
yes.
are to be heard through VC. Anyways, then we'll fix it on 8th of June.
Okay.
8th of June.
Much
Can a date one day earlier, madam, other than 8, madam, any day.
6th of June.
6, fine.
Much obliged, my lords.
Our learned counsel for the petitioners, including Mr. Manav Burman, who has appeared for the writ petitioner. You are for writ petitioner in item 11.
Yes, my lords.
Through VC,
Thank you, thank you.
through remote VC. Mr. Vijay Mohanty and his senior counsel, assisted by Mr. Ms. P. Sharma has appeared for the APSC, whereas Mr. R. Dhar, learned counsel. Government advocate, learned standing council PW has appeared for the department. On the request of learned council for both the sides, let these matters be listed again for admission hearing as fixed items on sixth of June,
Yes,
seventh of June,
Yes.
2023.
we'll do it in the second half.
No problem.
Much.
Yes, what is this?
Lordship, this is the original receipt copy, Lordship. Annexure 1990.
So they have filed an affidavit. is it
Yes,
not?
Lordship.
You file your reply by annexing this, and then we haul them up for contempt of court, perjury. Yes. When do you want it to be posted? Next Monday?
Lordship,
You file the affidavit within 3 days.
Lordship, after two, Lordship.
Huh?
June.
After 2 PM,
No, Lordship, 2 June.
2 June. Oh. 2 June, 5 June. Okay. Your name, please?
DJ Boro, Lordship.
Mr.
DJ Boro.
Mr. DJ Boro, learned counsel has appeared for the petitioner and seeks time till 2nd June 2023 to file a rejoinder affidavit. Miss, your name, please?
I am the proxy counsel, Lordship, M. Bose.
Miss M. Bose has appeared for the respondent bank. On the request of the petitioner's counsel, registry is directed to list this matter for motion again on 5th of June 2023 as a fixed item. In the meantime, rejoinder affidavit, if any, filed by the petitioner, be tagged with the record of this case. You take back this file in the affidavit. Yes, where is the council? What has happened to?
Your lordship, we have passed an order in the appellate office, the appeal, and thereby to uphold the order of compulsory retirement.
You have the copy of the
Yes.
order? Give it to me.
Page number 10 is the concrete.
Where is the council?
Your lordship, I have.
Do you know who is the council here?
Yes, your
Who
lordship.
is the
I-
council?
Mr. Chakrabarti, S. Chakrabarti.
Mr. S. Chakraborty.
Yes, sir.
Can you just reach out for him? We'll take it up after some time.
Your lordship, if allowed, your lordship, maybe take up on.
No, we'll take it up after half an hour, whether he comes or not. You please come after half an hour.
Yes, sir.
May I please your Lordship?
Hmm.
Mr. H. Gupta, CGC counsel, he is legs on another court.
Let him
So
be.
time
We'll
be-
take up the matter. This court will not wait. Whoever is there, you come prepared. We can't keep waiting. Those days are over. What is your case?
Petitioner before you, my lord, he is a CSF constable, my lord.
Hmm.
He was punished in the 2010, my lord, with on increment, withholding of an increment without cumulative effect.
Where is the order of penalty?
My lord, page 3, my lord, earlier, my lord, sorry, my lord.
Page 3.
No, my lord.
Page number?
Page 21, my lord.
This is the order you are challenging.
My lord, here, my lord, to page
Is
20,
this the order you are challenging?
yes, my lord.
What is
There-
the ground
there-
of challenge?
My lord, challenge that, my lord, since my lord, earlier, my lord, he was punished with, my lord, censure, my lord. Subsequently, my lord, that was revised by the respondent authority, my lord, and it was punished as my lord without withholding of one increment for a period of 1 year without cumulative effect, my lord. Therefore, my lord, in the year 2022, my lord, petition submitted the petition, my lord, saying that, my lord, that order should be revised, my lord. But while disposing of the said petition, my lord, the page 29, my lord, your lordship will find another 6, my lord. My lord, they have discussed about the granting of MSCP, ACP scheme, my lord.
Yes, but this order has been implemented.
My lord, that the
The order
earlier
has
orders are
been-
implemented.
Now, this order was passed in February 2010,
My-
13 years back.
My lord,
We'll
my lord. Yes,
discuss
yes,
it today.
my lord.
You can make your arguments, I'm dismissing it. We'll not entertain these petitions of
My
the
lord,
13 years.
yes, my lord.
Only
Yeah,
argue
yes,
on
yes.
how much cost is to be.
No, my lord.
Yes.
What I am submitting, my lord, the petitioner had submitted the petition in the year 2022. Definitely there was a delay, my lord.
Nothing,
But
nothing.
while disposing of the, my lord, representation, my lord, they had not discussed the content of the representation, my lord. They had discussed only MSCP, ACP scheme, my lord. That is why the.
Heard
at least-
Mr. S. Hawk, learned counsel appearing for the writ petitioner. Also, heard who's for the respondent?
Ace Gupta.
Also heard
Yes,
Mr. H. Gupta, learned CGC appearing for the respondents. By filing this writ petition, the petitioner has assailed the order dated 03/02/2010,
10, my lord.
by means of which the penalty of censure within court censure was enhanced to withholding within course, withholding of one increment for a period of 1 year without cumulative effect. Unquote. Mr. Hawk submits that the order of penalty has already been implemented, but according to him, the representation submitted by the petitioner was disposed of by the authorities without furnishing, disposed of by the authorities on
On my lord, 15/2/2023.
15/3/2023
Right.
without furnishing proper reasons.
My lord.
Where is that order? Where is that?
Page
29.
29, my lord. 15/2/2023. My lord, they have discussed only ACP, MCP scheme, my lord. Not, my grievance was not reduced.
The writ petitioner herein is serving, serving as a
Yes, my lord. Easily-
serving as an assistant sub-inspector, bracket ASI, in the Central Industrial Security Force. Full stop. তাৰপিছত দিব. This writ petition has been filed so and so. Disposed of by order dated 15/2/2023. According to Mr. Hawk, the representation of the petitioner was disposed of without furnishing proper reason. Full stop. However, on perusal of the representation, this court is unable to agree with such submission of petitioner's counsel. Be that as it may, an order of penalty imposed in the year 2010
10.
and already given effect to,
My lord.
in the opinion of this court, cannot be reopened today on the grounds urged in the writ petition. If the petitioner was vigilant about his rights and had a genuine grievance, there was nothing stopping him from approaching the court at an earlier date. Full stop. This court is therefore of the opinion that the claim of the petitioner has become stale at this point of time. And therefore,
Related issues.
precious judicial time need not be wasted
Right.
in reopening matters which attained finality way back in the year 2010.
Right.
This writ petition is accordingly closed.
Right.
Yes.
Oblige.
Item 16.
Please, your lordship, Mr. S. Bhattakur could not appear today due to some very sudden personal developments.
Yes.
Your
What is the case about?
Lordship, the petitioner is a enforcement checker, your lordship. There are disciplinary proceedings pending against him since 2019, your lordship, for which he has also been deprived of financial upgradation, your lordship. And also, he is entitled to be promoted, but because of the pendency of the disciplinary proceeding, he is not being considered, your lordship.
Lordship, my lord, today morning I talked to the Commissioner Transport, my lord. Lordship may dispose of the writ petition and give us a time frame. Within the time frame, we will conclude the DP.
Lordship,
My lord.
just one aspect, because of, we request the honorable court to pass a direction regarding financial upgradation also, which has been deprived, your lord.
They will take a call, my lord, after the
Well,
police.
consider your grievance
My lord.
and pass a reasoned order within how long?
2 months, my lord.
Yes, what do you have to say?
Lordship, actually, Mr. S. Bhattakur.
Oh, you go and ask S. Bhattakur. I'm passing the order after 10 minutes. After 10 minutes.
My lord. On interruption.
See, mister, these things has to stop. Somebody will have problem. We are here to do our job. We will continue to do our job. Unless it is a grave issue and some real heavy point of law is involved, this court will not entertain these players. This is a notification. So and so is busy, so and so has gone somewhere, so and so. We are not going to get into all these things. We have to keep doing our job. The judges also have a lot of things to handle. We can't help it. After 10 minutes, I'll pass the order. Whatever you want to say, you say.
Obliged.
Much obliged.
Yes, who's there in this case? Yes, what is the matter?
Lordship disclosing the appeared in the examination on a declaration of result, Lordship. For declaration result, Lordship. He said, Lord, he has qualified, but his result was not declared.
What do you have to say?
I have to take instruction to that.
All right, none appears for the petitioner on call, Mr. Essexwell and the government advocates. You are appearing as CG for government.
No, GS.
Nana G. Assam has appeared for the state and
1, 2 and
3 days time to obtain instruction responding to the allegation made in the petition. Prayer allowed, registered to list this matter again on 26/5/2000.
The petitioner praying for the promotion Anganwadi helper to worker lordship. The petitioner was appointed on 30/9/2007 as the Anganwadi helper at 436 number LP School, Nityanandpur Anganwadi Center Lordship. As per notification, petitioner was entitled to promotion to the post of Anganwadi worker. The notification is page number 17 Lordship.
So what is the prayer you have here?
Consider my claim. Already a petitioner name was recommended by the committee lordship.
Where is the recommendation?
Page number 22 lordship.
Yes, what is the name of the petitioner?
Sultana Begum Chaudhary lordship.
No, this recommendation is by which committee? What is this committee? Who is this president? Janab Khabir Hussain Lashkar? What is he? Who is he to recommend?
Kabir Hussain Lashkar, president of the Kitarbon Pachim Kitar General Meeting.
Part 1 Anganwadi Center.
Take down. I'm disposing it off. You submit representation before the director. He'll look into your grievance and take appropriate steps as may be permissible under the law. Heard Ms. E. Begum Learned Counsel appearing for the petitioner. Also heard Mr. R. Dhar Learned Government Advocate Assam appearing on behalf of the respondent numbers.
All men.
1 to 4. Full stop. The read petitioner hearing claims to be serving as Anganwadi helper in the number 436, what is the name of the Anganwadi center?
He is appointed at 436 number LP School, Nityanandpur Anganwadi Center.
Anganwadi helper at 436 number NO dot L full stop P full stop school, Nityanandpur Anganwadi Center number 161. Full stop. According to the petitioner, she has the requisite qualification and experience for being promoted, stroke upgraded to the post of Anganwadi worker. Full stop. Notwithstanding the same, no action has been taken to promote her, stroke upgrade her to the post of Anganwadi worker. Hence this writ petition. Full stop. Law is firmly settled that a candidate would have right to be considered for promotion if he or she comes within the zone of consideration. Whether the candidate comes within the zone of consideration is a matter for the departmental authority to verify, to ascertain. Full stop. However, law is equally well settled that right to be considered for promotion is a fundamental right. Therefore, without expressing any opinion on the merit of the claim projected by the petitioner in this writ petition, with the consent of both the sides, I dispose of this writ petition by granting leave to the petitioner to submit appropriate representation before the respond number 3, ventilating her grievance in the matter. Full stop. If a representation is submitted within a week from today, by enclosing a certified copy of this order, the same be looked into. Full stop. If the petitioner comes within the zone of consideration for promotion, stroke upgradation to the post of Anganwadi worker and fulfills the requirement of law, fulfills the eligibility norms, and also if there is vacancy available for accommodating the petitioner, then appropriate steps be taken by the authorities for consideration of her case as per the existing norms. The aforesaid exercise be carried out as expeditiously as possible, preferably within three months from the date of receipt of a copy of the representation. The petition stands disposed
Now,
of.
she applied the Anganwadi worker at 52 number Pachim Kitarban, and earlier she was appointed at the 436 number LP school.
You put everything in your representation.
My lord, let her also submit this copy of the writ petition along with the representation. That
Why? Who will decide the writ petition?
No, no, my lord, that will help, my lord, all these facts, my lord.
The district's welfare officer cannot decide the writ petition. Let him entertain
He
the representation.
My lord, let her file it before the director. It will be expeditious, my lord.
Actually, then respond number 2. Director social.
It will cut short the time, my lord.
May it please your lordship, the petitioners are appointed as senior instructors on part-time basis, your lordship, purely on temporary basis. Now the payment was fixed at 250 rupees per hour, it was capped. And maximum for 3 hours they can be paid. Now there was a notification which is at page 7, wherein the similarly situated person in the rank of lecturer and assistant professors, their pay was increased from 400 to 1000. And the lecturers were increased from 350 to 900. And accordingly, a proposal was made by the Director of Technical Education at page 85 to increase our pay at 500 rupees, your lordship, from 250. But that has not been done, your lordship. I'm only playing from that.
My lord, may issue notice that this will come.
All right, I heard Mr. R. Sinha, Learned Counsel for the writ petitioners. The petitioners herein are working as senior instructors in different engineering colleges.
Polytechnics in different polytechnic and engineering college.
That's what I'm saying.
I'm sorry, your
What is
lordship.
the problem? Engineering colleges and polytechnics is different from polytechnics and engineering college. Engineering colleges and polytechnics of Assam. Most of the grievance of the petitioners is that despite recommendations being made by appropriate authorities, no steps have been taken for enhancement of their remuneration. Although such grievance of similarly situated employees have already been responded to by the authorities. First of Mr. K. Gogoi, Line Standing Council, Technical, this is higher education. Technical Education Department, Assam, prays for 6 weeks time to obtain inspection in the matter. NOM 6 weeks, since Mr. P. Nayak, Learned.
Respond number 2.
Acha, Mr. C.S. Hazarika, Learned Government Advocate Assam, has accepted notice for respond number 1. Mr. P. Nayak, Learned SC Finance, for respond number 2, and Mr. K. Gogoi for respond numbers 3 to 6. No formal notice is required to be sent in this case. Extra copy of the writ petition be furnished to the Learned Department Council requisite in numbers, so as to enable them to obtain instruction. Let this matter be listed again after 6 weeks as a fixed item.
Lordship.
Lordship, it may be disposed of.
Yes. Heard Mr. S. Bairagi,
As they, your lord.
S. Day,
Yes, sir.
Learned Counsel for the writ petitioner. Also heard Ms. M. D. Bora, Learned
Standing Council Transport.
Standing Council Transport Department, Assam, appearing for the respondents. The case of the petitioner is that while working as an enforcement checker in the establishment of district transport officer, bracket enforcement, bracket close, Kamrup, bracket M, a departmental proceeding was initiated against him and the petitioner was also placed under suspension. Full stop. Subsequently, the petitioner has been reinstated in his post. However, the departmental proceeding initiated in the year 2019 has not yet been concluded, as a result of which the petitioner has been deprived of all financial benefits attached to the post. Full stop. Mr. Day further submits that due to the pendency of the departmental proceeding, the petitioner has also not been considered for promotion
Yes, your lord.
to the next higher post. Full stop. Hence this writ petition. Full stop. Ms. Bora, Learned SC Transport Department submits on instruction that if this writ petition is disposed of with a direction to consider the grievance of the petitioner in a time-bound manner and pass appropriate orders therein, the departmental authorities will do the needful. Full stop. Mr. Day has also agreed to the said recourse. In view of the above, this writ petition is being disposed of at this stage of motion hearing with a direction upon the respondent number,
Lordship is a Commissioner Transport, but he is not a party.
direction upon the
Then respondent three,
Commissioner-
my lord, three, Joint Commissioner is a party. Commissioner Transport is not a party.
Commissioner to the Government of Assam,
Transport.
Department of Transport,
My lord.
Dispute,
Lordship, Khanapara, my lord. Commissioner is separate.
Department of Transport, Khanapara, to look into the grievance of the petitioner and thereafter pass appropriate orders so as to redress his grievance in accordance with law.
My lord.
Full stop. The facilitating the above, the petitioner to furnish a certified copy of this order before the appropriate authority as indicated herein above within a week from today. Full stop. If the certified copy as directed by this court is produced before the departmental commissioner, the exercise as directed by this court be undertaken forthwith
My lord.
and the process be concluded as expeditiously as possible, but not later than
2 months.
2 months from the date of receipt of the certified copy. If the petitioner continues to remain aggrieved in the matter, it will be open for him to approach this court by filing fresh writ petition.
My lord. Deeply obliged, my lord.
I'm most grateful. Your Lord.
The petitioners had participated in a selection process for the CAPF Constable General Duty, my lord, and they were denied consideration in the unreserved class because they had taken a certain.
So similar matters.
Yes, my lord, that order.
Lordship, WPC 2758 of 23.
Yes.
Friday.
Disposed of. Friday, please.
How many more cases do you have like this, Mister?
My lord, one or two.
One day we'll fix it only for this.
One or two.
One or two more.
They come up, my lord. From the
Not
villages.
many.
Not very much left.
These are very productive cases.
They get a job. my lord.
Productivity point of view, this is very. All right,
The difference would be, my lord.
how many, all the petitioners are
Two
entered?
petitioners are here, my lord. One is an ST, one is an OBC. Both will fit into the unreserved category.
One is,
The first petitioner is an ST
Hmm.
and the second petitioner is an OBC. They both fit into the unreserved category on the basis of the marks.
so both are reserve category.
Yes. Only reserved category candidates were not given the benefit.
Disposed of.
Obliged.
Circular.
Please, madam, the petitioner is responding to the advertisement issued by the respondent number 2, district judge Borpatra, for 3 posts, 2 for regular appointment, 1 for contextual appointment of the peon. Petitioner has applied for the contextual and the regular appointment. And the common examination was held, viva was held, and thereafter 2 candidates have been appointed in the regular post from the regular list, and the one Narayan Das, who respondent number 3, who has not applied for a contextual post, he was appointed in that post. And one Gautam Das, respondent number 4, he has not applied for a contextual post. He is also kept in waiting list, placing the petitioner below him. As these 2 candidates have not applied for the contextual post, if they were not brought to the contextual line, then petitioner would have got appointment.
Yes. So you made the High Court standing, you have copy on standing council High Court.
Yes,
Yes,
I have copies, sir, my lord.
no, it is not showing.
I don't know, actually, copy.
No, if it is not served, we will not take it up today. Copy has been
I
served.
put it,
Your junior, you will know.
copy this, copy of sir, my lord, not petition.
Just check if copy has been served. Let it be listed again by showing the name of standing council GHC. Because this is a recruitment in the district judge's establishment. You have heard Mr. K. Sharma. Learned Counsel.
Definitely, the standing council will have to receive copy, but we have served it actually. I don't know.
Let it be listed which showing the name of the standing council.
Whether it will be listed under that. Then under that may fix.
Heard Mr. K. Sharma. Learned Counsel for the petition. Since the controversy involved in this writ petition parties to appointments made in the district judiciary. This matter be listed again by showing the name of Learned Standing Council, Guwahati High Court, bracket GHC in the cause list. Now, let this matter be listed for motion again by showing the name of Learned GHC in the cause list. It will come from
Notice might be issued, we will serve copy on them.
Sorry?
If your lordship issue notice to the respondent, we will serve copy on them.
No, that will be later on. Now, at the time of filing, copy has to be served to the standing council. If it has been done, then you don't worry. If it has not been done, it will again be adjourned next day.
Next time, I guess.
Any day after tomorrow? Day after tomorrow.
Next time, I guess.
May please your lordship.
Yes.
In this case, the name of the petitioner for rejected by SLC lordship for appointment corporation guard for grade 3 post. Page 24 lordship. Speaking order was passed by department lordship. And his page 25.
Father died when?
Died in the year 2011.
So these are covered cases. After so many years, after 22 years, this cannot be. Up to 22, no, this after 13 years, no writ of mandamus can be issued.
In the 2011, fathers died. I applied immediately within 1 month lordship. But it was rejected in the 2015 by SLC and speaking order was 2017 Lordship.
Hmm.
Then did
And after 5 years, you have come.
Lordship because my due to illness of my mother and my COVID-19 Lordship.
Can't help it. Law is well settled now. No writ can be issued. You read the judgments because it will affect the rights of other candidates who come in. These are for immediate relief. Can't be after 12 years, 13 years, compassionate appointment.
Like
Not
2017 Lordship, I was speaking order was 2017 Lordship.
maybe 17, but since 17, it is 5 years. Yes, heard Mr. K.D. Sharma, learned counsel appearing for the writ petitioner. Also heard Mr. B. Upamendu, learned standing counsel, Health and Family Welfare Department, Assam, appearing for the respondent numbers
1 and 4.
1 and 4. Next up, Mr. H. Sharma, learned additional senior government advocate, Assam, has appeared for respondent numbers 2 and 3, and Mr. P. Nayak for respondent number 5. First up. The petitioner's father died in harness on 29/11/2011 while serving as, what was he serving as?
Serving as
Serving as
Sub-Inspector of Statistics
Sub-Inspector of Statistics
under Director of Health Service.
under the Directorate of Health Services.
Family Welfare.
After the death of his father, the petitioner submitted an application. Father died on 2/10/2011. Submitted an application on 29/11/2011, seeking appointment on compassionate ground. The district level committee (DLC) had initially recommended the case of the petitioner for appointment in a grade 3 post, but by the resolution adopted in the meeting dated 27/11/2015, the state level committee (SLC) had rejected his prayer. On the ground of want of vacancies. First up. Then petitioner submitted an appeal before the.
Appeal not filed Lordship. Speaking
No, what is the order 24/4/2017?
24 SP, page 25 Lordship. Speaking order is there stated Lordship. Page 25. Page 25, from below is a father 79 candidates.
No, Mr. Sharma, on 27/11/2015.
My
was
rejected Lordship.
Yes, rejected by,
Rejected by SLC Lordship.
then again you preferred what?
No, I have not preferred it Lordship.
Then what is this 24/4/2017?
That this one past speaking order Lordship passed. This past speaking order of the SLCs or has been passed by the speaking order, informed by speaking order Lordship. By
Thereafter, on 24/4/2017, the petitioner was informed about the decision of the SLC by a speaking order. Full stop. Assailing the minutes of the meeting dated 27/11/2015, as well as the speaking order dated 24/4/2017, the present writ petition has been filed. What is to be noted here in that the scheme for appointment on compassionate ground has been framed by the government so as to provide immediate relief to the family member of the deceased government employee who would be plunged into financial difficulties due to the premature demise of the government servant. Full stop. Law is firmly settled that the scheme for appointment on compassionate ground does not confer any indefeasible right on any person to claim employment in government job. Full stop. In the present case, the father of the petitioner died in the year 2011, and thereafter his application was rejected by the SLC on 27/11/2015. Full stop. The petitioner had admittedly learned about the decision of the SLC in the year 2017, Full stop. However, the present writ petition has been filed after a lapse of more than 5 years. Full stop. The explanation for delay as furnished by the petitioner's counsel is not at all convincing. Full stop. If the petitioner could survive for 12 long years after the demise of his father, there is no reason for this court to believe that unless compassionate appointment is provided to the petitioner, he and his family members would not be able to survive. Under the circumstances, this court does not find any good ground to entertain this writ petition. Conversely, this writ petition is found to be hit by the principles of laches, negligence and delay. Full stop. Moreover, the scheme for appointment of on compassionate ground has also been discontinued by the state government since the year 2017. As such, no mandamus would lie at this stage, directing the respondents to appoint the petitioner on compassionate ground. For the reasons stated here and above, this writ petition is held to be devoid of any merit and is accordingly dismissed.
Matter pertains to non-consideration of promotion to the post of deputy ranger. Whereas the person who is junior to him, me, my lord, has been promoted to the post of deputy ranger. Lordship may kindly look into page 38. This is the promotion order. Although now, my lord, I am retired from service. So I am
Retired.
yes,
Then what is that you want?
my lord, the difference of pension and my lord, the other retirement dues, which I am.
When did you retire from service?
My lord, I am retired from service on 31/3/2021.
31/3/2021.
21.
And when was your junior promoted?
My lord, on 17/1/2020. 17/1/2020.
17/1/2020. Why did you not approach this court while you were in service?
My lord, at that point of time, I am not aware regarding the promotion.
We'll close it. Can't help it.
My lord, only
No,
my lord, I am entitled because lordship's own judgment, my lord. It is
Own
strict
judgment
document
may
for
be-
my lordship.
you have to be vigilant, mister. If your junior is promoted by superseding you, you just sit over the matter and come to the court after 3 years, 4 years. Now you want the department to reopen everything. You have already retired. Will not entertain these things. Let
Only
it be
this-
settled at a higher forum. These are just breeding litigation without any purpose.
And in fact, after only litigation, my lord, they have given my promotion, my lord, earlier to promotion. That is
No,
Forester 2 and
the
Forester
only
1.
question I am asking is, why did your client not approach the court on time? When he was in service, that was the time his junior superseded him. He accepted it.
Not actually, my lord. He is not aware because the Forester 1, my lord,
Let him live in peace. Who made him aware now? You? Huh?
after retirement, he got the information, my
Will
lord.
not
And
entertain.
immediately thereafter, he had made RTI application.
Yes,
my
what do you have to say?
Lordship, both of them have retired. The petitioner has also retired and the person about whom he's talking, he has also retired. And the earlier representation that he's talking about, that was complied with. So he was promoted to the grade of Forester 1.
No, last representative
Grade
was
of
still pending.
constable. So you argue and satisfy this court. What relief can be granted to you now?
Only my prayer is that, my lord, I am entitled on difference of pension and retirement dues only.
No, I'm
Because
so-
on the last, because my representation is.
I
still
can
pending.
give you half an hour time to prepare and argue the matter. Otherwise, I'll close it.
My lord, I
After
appreciate-
retirement, these things cannot be reopened. You think the department has nothing else to do? You will see, slip over your right and then they come
It
to
is
court
done,
whenever
but
you feel like. And
Injustice
then
is
we'll
done.
direct them to reopen everything. People are, the departmental, they may have some issues here and there, we'll look into it. But it's not that the department is sitting idle. If you fail to protect your right, why should others pay the price for it? You want half an hour, I can take it at 12, but I'll close the matter.
Ultimately, my lord,
Yes.
decision will be.
Yes. Nowadays, we'll have to be strict. These things can't happen for the asking. But you can convince the court on making out a case. I am willing to hear you. But don't say that I have no explanation, but still pass an order.
Then lordship,
That will not do.
next week, my lord, in the meantime, I will.
All right. On the request of Mr. So-and-so, I counsel for the petitioner. This matter is directed to be posted again in the next week. In the meantime, Miss
M. Kalita, your lordship,
M. Kalika, Learned Standing Council,
Forest Department.
Forest Department, Assam, to obtain instruction. Mr. B. Chaudhary, Learned
BTC Lordship.
and Standing Council, BTP is also present on behalf of the council. One extra copy each be furnished to the Learned Department.
Highly obliged.
The other party was supposed to be here at 11:30. Lordship. They have
Sorry?
not come.
What is,
The issue is regarding the constitution of CSB Central Recruitment Board in Bodoland area, Lordship. There is an order by which although no stay was granted, but there was a direction that in case we reconstitute it, there should be a leave from the honorable court, which Lordship will find in our IA at page 21. And they were supposed to file an affidavit.
who is appearing for the,
Mr. Mohant, the advocate, Lordship, we have informed his assisting counsel was here also when I made the mention.
you upgraded because.
Yes, Lordship.
uh, This can wait till Thursday. It doesn't
Lordship,
suit you,
Difficult, Lordship.
but I will not pass an order.
No, I do not want. Let it be after 5 minutes, Lordship.
So they have passed an order. You file a fresh appeal. telling me-
lord, I will just incorporate by amending the present writ petition.
No, without pleadings, we will not entertain it.
No, we'll file an application for amendment of the.
Mr. Chakravarti, you will do it. It will take you 1 year to get an order.
My lord, with liberty.
Amendment means first you will have to file application for amendment. They will file objection, we will hear it. If it is allowed, you will file fresh petition. They will file affidavit. You want to take that course? That is of
Well-
course permissible. You want to do that?
No, my lord.
All right. Heard Mr. S. Chakravarti, learned counsel for the petitioner. Also heard Mr. M. Sharma, learned standing counsel. Which bank is this?
Indian Bank.
Indian Bank.
So 1 to
Indian
5,
Bank
1 to 4.
appearing for respondent numbers 1 to 5, who submits on the basis of instruction obtained as per order dated 12/5/2023 passed by this court, that the appeal preferred by the petitioner against the order of compulsory retirement has been disposed of by the authorities by order dated
12/5.
10/5.
10/5/2023, thereby rejecting his appeal. First of, Mr. Sharma has produced a copy of the order passed by the appellate authority, perusal of which goes to show that the order imposing the penalty of compulsory retirement has been affirmed by the departmental authorities. Situated thus, Mr. S. Chakravarti, learned counsel for the petitioner, seeks leave of this court to withdraw this writ petition with liberty to file afresh by assailing the order passed by the appellate authority. Prayer allowed. This writ petition stands disposed of on withdrawal with liberty as paid for. You will need to have pleadings, Mr.
My lord, my lord.
Chakravarti. Have it.
Your lordship, I am for respondent number 1 to 4.
Respond numbers 1 to 4.
For admission, item 26.
Yes.
Mention for his name.
Yes.
Long time, madam.
It's similar.
It was last listed in 2020.
All top of the matter lists, matters are coming after 3 years.
Yes.
So no adjournment.
Dispose of, my lord.
Already, matter has been.
Actually, I appear for the state, madam, main respondents, my lord. the
This
CIS
matter has been disposed of.
Can be disposed of.
Can be disposed of, my lord.
All right, what is it?
Yes, my lord. Here, my lord, departmental proceeding has been initiated against me, my lord, for non-submission of the ST certificate, my lord, in a revised form. Kindly see the article of search, my lord.
It's just 1 minute. Yes, so what is the, how it can be disposed of?
My lord, subsequently in a similar case, my lord, in this case, Fukan Deuri, my lord, Learned single judge allowed, my lord, subsequently, in the preferred appeal, my lord. That is dismissed. But, my lord, with a reference to the, my lord, to send back the matter to the state level, my lord, screening committee, hyper screening committee. And because, my lord, that CSF authority cannot determine the, my lord, the certificate, that screening committee will do, my lord. In that way, my lord, following the Honorable Supreme Court direction of Kumari Madhuri, but this case, my lord, in this way, my lord.
So this matter can be referred to the screening committee.
Screening committee, my
Until
lord.
then,
Because he is a ST of, my lord, Arunachal Pradesh, and certificate was that, my lord, he is a ST, deputy, but it is recognized in Assam. That was the certificate issued, my lord, page 18. And in that case, my lord, that's though it is, my lord, rejected, dismissed appeal, my lord, ultimately referred to the screening committee, my lord.
My lord, your lordship judgments are there, my lord, division bench. Your lordship.
give me.
2017. It's paragraph 12 and 13.
So is there a screening committee for Arunachal? There is.
Exactly, I do not know, my lord, I have to take instruction on that, man. Short time, my lord. I'll take instruction. It should be there, my lord, after Madhuri Patel, but I am not sure.
No, but we'll dispose of this matter today, right now, before 12 o'clock. You have to take instruction right now. We are in the age of information technology. At 12.
Yes.
At 12.
Yes.
You just tell us if it is there.
Yes.
We'll refer to them until the opinion of the screening committee comes, no further proceeding
My lord.
against the petitioner. That's all. Only issue is whether the old format certificate is genuine or not.
Yes, my lord.
That is
That
the
is-
only issue.
They have given a report, my lord, that is genuine.
Who has given a report?
My lord, this deputy commissioner, my lord. Page 7 of my affidavit in reply, my lord. There was information sought by the, my lord, deputy inspector general of CIS.
They have given the certificate, but whether they can the power to give, my lord, he is a ST in.
All right, you
Yes,
place
sir.
all materials before the screening committee.
Yes.
That is the process. Division benches also said the same thing.
But the authority is not issuing, my lord, ST certificate in the revised format. There is the problem.
Oh, he's not
Now he
understanding.
cannot. As far as.
Can you please find out if it is there, then
Yes,
we
yes.
can pass an order. Yes. The screening committee will verify, there is already
Yes.
order of the division bench.
Yes, my lord.
Until the time screening committee's report comes, no coercive action against the petitioner, that's all. How many writ petitions are there?
My lord, only one.
And what is the IA about?
They have filed.
We have filed for stay vacating, my lord. It was last listed on 4/2020 and it's supposed to be listed for final disposal.
Or I will just take it up at 12, yes.
Item 25, part of matter.
May it please, your lordship.
Mr. Chaudhary, this matter will take some time, perhaps.
Of course.
We'll take it after the other cases.
Okay.
Because now this, the practice is that nobody wants to go for hearing. So admission matters will be listed after hearing now. Everybody wants all matters to be finally heard in admission.
No
What to
problem,
do?
no problem.
But anyway, this is nothing to do with your case.
Yes.
Generally speaking, the trend is that everybody
That
wants.
we have also noticed.
Then what happens is, then what is the point in having other?
Exactly.
But today we'll take it. What is this matter about?
My lord, this is regarding these petitioners. They were all, my lord, the vendors in this Masqua market. Lordship knows there was an incident of fire, then it was, sought to be reconstructed, then various disputes arose.
But this is
Matter
a
went
bench
to
four
Supreme
matter.
Court.
This is a bench four matter.
Part had matter.
It was part of it.
Parted.
Not a very longest matter, my
It
lord.
was 1 year back. It was made parted 1 year back almost.
But the status is still there, my lord.
We'll see after the.
We'll have it in the second half, my lord.
So I think it will be difficult for the other council to appear before 12 o'clock. I think, I do not know whether it is deliberated or not. Let it come up day after tomorrow, Lordship.
Day after two.
I'll come back on that.
Learned-
61.
All right. Mr. So.
RB Guha,
Mr. R B Guha has appeared for the applicant and seeks posting of this matter again day after tomorrow. Mr. D. Saikal, learned AG Assam has expressed urgency in the matter. As such, registered in this case again day after tomorrow as fixed item.
Hello.
Item 27, format matter.
Last occasion, Lordship has called for the records. We may be allowed to call for, go through the record also, Lordship. And secondly, as a abandoned question, we have also challenged the regulation order. Lordship has pointed out there's no challenge. We have filed a petition separately, selling the regulation order. If Lordship want to take this matter along with that, or today,
No, but if you challenge it, that challenge by itself will not stop this court from hearing it. That
Lordship.
challenge has come late.
Lordship.
If you succeed there, supposing these writ petitions goes in your favor.
Ah.
Matter ends. If it doesn't go in your favor,
Then Lordship.
then when that will be decided, then you will get the benefit. Today, because the court says you have not challenged, then
No, Lordship. As a abandoned question, we have filed, Lordship.
that's right.
Because Lordship, Supreme Court has Momota Houses case, Supreme Court has categorically stated that subsequent regulation of order also do not give him any seniority or anything. Momota Houses case, Supreme Court, Lordship, Odisha.
That's right. That's right. So what is to be done? You ready for hearing?
We have not gone through the record, Lordship. If Lordship allow us to,
Yes, yes. Yes, then we'll take it up after some time. Yes. Be here around 1 o'clock or maybe at 2 we can.
at
take it.
two, at will be better.
At two.
At two, Lordship.
Item 29.
Yes, what is this?
My lord, this is for recruitment into the defense. Yes. For appointment to the defense department, my lord. The petitioner was selected for recruitment into the army. And medically fit, declared medically fit. But he has not been appointed to the post he applied for.
Nobody is appearing. Union of India is not represented in this case. What is your response to this?
Lordship, I'm not appearing, Lordship. After some time, Lordship, I'm just informed, Lordship.
Inform whom?
My lord. 29. I just informed MSC Borua is there, Lord. Or I just checked the order and he's appearing, Lordship.
You call it, we'll wait for something.
Lordship, sorry to interrupt in the middle. Lordship has permitted us to see the records. So he is confused whether his permission is granted or not. Lordship, I can
Yes.
show it. Obliged.
It is functional, my lord.
But after this,
Yes,
after this call that matter. Arunachal, please.
May, please, your lordship. My lord, I travel your lordship to order dated 7/12/22 and the subsequent order.
So for disposal,
My lord, because there was, my lord, I am not getting my salary. Previously it was paid, suddenly it was stopped. Your lordship may peruse the order dated 7/12/22, my lord. Details has been laid down there.
yes, what is the stand of the revenue department?
Revenue lordship.
Yes, there was a direction to file affidavit.
We have filed it, Lordship, already. The last occasion, government.
Lordship, most probably the deputy commissioner Morigaon was directed respondent number 4.
Hmm.
And lordship, we have sent the letter to them. And we have received the instructions also, but it was misplaced somewhere. But today, just now, lordship, I rang them and they have sent me in my WhatsApp.
Hmm.
So if lordship may fix
So
it.
what is the instruction?
They have also sent one affidavit, but I have not found it. If your lordship fix it day after tomorrow, if on the basis of the instructions, if it can be disposed of, otherwise, lordship, I have read the letter to us.
Hmm.
The above. But they are posted in a non-sanctioned post, lordship, but even then, the above mentioned government services may kindly be regularized in view of the government's letter number so and so of 2006.
You file the affidavit, we'll dispose it of on Friday. File the affidavit day after tomorrow, you file it.
By day after tomorrow,
Hmm.
lordship.
What is it?
Next week, lordship, if your lordship fix it, next week, lordship.
What is, the instruction has come only.
Uh,
By Thursday, you bring it on record. By Thursday.
Lordship,
Today is Monday,
lordship.
and then we'll close it. Heard Mr. P.K. Rajendra, counsel for the petitioners. Also heard Mr. H. Sharma, learned additional senior government advocate, Assam, appearing for the state, who submits that he has just received instructions and fixed time till 25/5/2023 to bring those on record in the form of an instruction. Full stop. It appears from the oral submissions made by Mr. Sharma that the read petition can be disposed of
Lordship.
on the basis of stand taken by the department in the affidavit. Mr. S. Datta, Learned Standing Council, Revenue Department, Assam, is also present and agrees to the said proposition. In view of the above, register to list this matter as a fixed item again on 26 for admission in the disposal column.
Lordship.
Matter 26.
Take down, heard Mr. R. Deori, Learned Council.
SK Dev.
SK Deori, Learned Council, appearing for the petitioner. Also heard Mr. KK Parashar, Learned CGC, appearing for the respond numbers 1 to 4. Mr. PD Goswami, Learned Additional AG, State of Arunachal Pradesh, has appeared for respond numbers 5, 6. Sorry,
No, 3 and 4, madam.
all right, 1 minute, there is a
I am
difference.
for 1 and 2, madam.
Mr. Parashar for 1 and Two, one and two, and Mr. V.D. Goswami, learned additional AG, Arunachal Pradesh, for respond numbers 3 and 4. First up, the read petitioner claims that he belongs to the Deori community, which is a recognized scheduled tribe, bracket ST, in the state of Arunachal Pradesh. Full stop.
No, my lord, Assam, my lord. Page 20 is the certificate. ST is recognized in Assam, but certificate given by Arunachal Pradesh.
Which is a recognized ST community in the state of Assam. However, the petitioner was earlier issued a ST certificate by the authorities in the state of Arunachal Pradesh, based on which he had secured his appointment in the
CISF money.
Central Industrial Force Security Force, bracket CISF. First up, the petitioner is presently posted at
Nazira.
Nazira, Assam. Full stop. However, in Nazira, Assam, full stop. The CISF authorities had taken note of the fact that the certificate, ST certificate produced by the petitioner was in the within quotes old format and did not comply with the requirement of the within quotes new format. It was suspected that the ST certificate relied upon by the petitioner was a forged one. Full stop. On such assumption, a departmental proceeding was initiated against the petitioner.
Page 21, 14, 11, 15.
By issuing a memorandum dated 14/11/2018. Full stop. The ST certificate dated 1/7/1988 relied upon by the petitioner was a forged one. Upar it was. A departmental proceeding was initiated against him by serving memorandum dated so and so. First, aggrieved thereby, the petitioner has approached this court by filing the present writ petition, inter alia contending that the state of Arunachal Pradesh has taken a decision not to issue ST certificate in new format to anyone, is it? Or only to Deori?
No, to any.
Not to anyone, my lord.
Only
Dairy community.
Every Kasari and my lord missing.
To the Deori within quotes, Kachari within quotes, and missing within quotes community, as a result of which petitioner is not in a position to produce the ST certificate in new format. First up, Mr. Deori submits that the ST certificate issued to the petitioner has been authenticated by the Deputy Commissioner of
Lohit district.
Lohit District, Teju, and therefore there was no justifiable ground for the authorities to suspect that the same was a false document. First up, contending that Deoris are recognized, Deori community is a recognized ST community in the state of Arunachal Pradesh. Mr. S.K. Deori, learned counsel for the petitioner, has placed reliance on a decision of this court rendered in the case of state of Arunachal Pradesh versus Putul Chandra Deori, reported in 2017 bracket 2 bracket close GLT 647. Full stop. Responding to the above, Mr. Parasar, learned CGC submits that in a similar matter, the division bench of this court had earlier directed the state level, what is it called?
Screening committee.
State level screening committee
Screening committee.
to verify the genuineness of ST certificate.
SC and ST.
SC/ST certificate. And furnish its opinion in the matter. Full stop. The aforesaid direction was issued by the division bench by following the guidelines laid down in the case of Kumari Madhuri Patil and another versus additional commissioner, tribal development and others reported in 1994 bracket close 6 SSC 241. And therefore, a similar order be passed in the present case as well. Mr. Goswami, learned additional AG, State of Arunachal Pradesh, also submits that he would have no objection if such an order is passed. First up, Mr. R.S. Deori, learned counsel for the petitioner, has also consented to the said recourse. Full stop. A copy of the order dated 28/10/2021 passed by the division bench in writ appeal number 39/2021 has been placed before this court. I have perused the same and find that in a more or less, in a case involving more or less similar factual backdrop, wherein the genuinity of a ST certificate issued by the state of Arunachal Pradesh was called into question. This court had directed the state government to constitute a screening committee as per the decision of the apex court in the case of Kumari Madhuri Patil bracket Supra, so as to take a decision on the validity of the certificate granted to the ST community person. Full stop. The screening committee was also directed to issue notice upon the affected person and so as to produce all relevant documents before taking a decision in the matter. Full stop. Considering the facts and circumstances of the case, I am of the view that a similar direction can be issued in this case as well. Full stop. Mr. Goswami, learned additional AG AP, has also confirmed that there is a state level screening committee constituted by the state of Arunachal Pradesh to look into such grievances. Full stop. As such, this writ petition stands disposed of with a direction upon the state level committee to verify the genuineness of the ST certificate dated 1/7/1988 issued to the writ petitioner herein after examining the relevant records. Full stop. Facilitating the above, the petitioner to produce a certified copy of this order before the state level screening committee within 3 weeks from today. Until such time, the state level screening committee renders its opinion on the validity of the ST certificate. Departmental proceeding initiated against the petitioner shall remain suspended. If the petitioner continues to remain aggrieved even after the opinion of the state level screening committee is rendered, it will be open for him to approach this court once again by filing a fresh writ petition.
Only one thing was, he is enjoying the stay order since 2018, almost 5 years. So a time frame regarding the screening committee.
Then we'll produce a certified copy of this, then you write. Since the petitioner is enjoying the benefit of a stay order passed in WPC number 8607/2018 since the year 2018, the state level screening committee is requested to render its opinion as expeditiously as possible, but not later than 3 months from the date of appearance of the petitioner. Then that's it. Then rest of it will be disposed of. And in the IA, it will stand disposed of. Because of
Obliged, sir.
Obliged.
So what has happened? SLPS?
SLP is allowed the which they are relying, it has been set aside, Lordship, which they are relying on. Lordship.
They are relying on which order?
WPC 45. In WPC 5520/2012, they are relying on Lordship. It has been set aside by the SLP, Lordship. Both the orders are there, Lordship. SLP order was out.
You continue in the first law. Don't come in the second law. Huh? No, I mean, second time you don't need to come. Emergency, allowed to come from 2 p.m. Short order, right? So that second time you don't have to come. Second time, yes. And where is the SLP? So order has been set aside.
Yes, madam.
Then what remains here?
Matter may be disposed of to on merit measure.
All right. We list it for disposal and admission. Heard Mr. So-and-so and counsel for the petitioner, also heard Mr. Assessor and Government Advocate Assam appearing for the respondents who submits that the order dated 04/01/2016 passed by the Learned Single Judge in WPC number 5520/2012 has since been interfered with by the Honorable Supreme Court. In civil appeal number 4585/2018, and therefore this writ petition has become infractious. Mr. Ramshari and counsel for the petitioner on the other hand submits that the instant writ petition be decided on its own merit without being influenced by the order dated when so passed by the Learned Single Judge 4/1/2016 passed by the Learned Single Judge. In view of the above and on the request of Learned Counsel for the parties, let this matter be lifted for disposal on admission after 2 weeks. As a fixed item. Disposal at the stage of admission. 30 already, or I think order has been passed. That is already already passed. Yes.
No, the matter pertains to denial of the salaries as per the seventh pay commission. Here the petitioners all along they were drawing the salaries under the pay commission fifth, sixth and seventh. All of a sudden it was stopped. Now otherwise the biddings are complete. The
So Mr. Day, we are now creating a new category,
lordship.
disposal and admission.
In fact, that was what
The matters will be listed just before the hearing, because everybody wants hearing
lordship.
at admission. Why should we have it before orders and other matters?
Lordship.
So if you want disposal or admission, we can,
Look, in fact, that would be better,
yes. Mr. R. D. Learned Counsel for the petitioner also have Mr. B. Chaudhary, Learned SC,
For agriculture.
Agriculture Department, Assam. It is submitted at the bar that this matter is ready as regards pleadings and service and can be taken up for disposal at this stage of admission hearing. In view of the above and on the request of Learned Counsel for both the sides, registry to list this case for disposal at this stage of admission hearing after 3 weeks as fixed item.
May please.
Yes,
Lordship, petitioner is deprived of promotion, Lordship. But the petitioner already retired, Lordship, and his junior has been promoted, Lordship. Lordship,
already retired. Retired when?
31st March 2021, Lordship. And
Who is his junior?
Lordship, in respondent number, Lordship, like Lordship kindly. Addition list, Lordship, kindly. Page number 28, Lordship. And petitioner name is page number 30, Lordship. Serial number 19, Lordship.
So this is promotion to which post?
Lordship, to superintendent, Lordship, from UDA, Lordship.
Right, so what, now the promotion cannot be given.
Lordship.
What is that you want now?
Lordship, petitioner approached the Honorable Court, Lordship, before retirement, Lordship, in 19, Lordship. And now he is retired, Lordship. For promotional benefit, Lordship, pension benefit.
Show me a judgment which permits that. Some authority, some. So argue that it is permissible.
Lordship. Lordship.
I am saying,
Lordship.
since your client is retired, this writ petition has become infructuous. Convince the court that it is not correct.
Lordship. And Lordship, from retirement benefit, Lordship, I otherwise if from
You retired as UDA.
Lordship,
Now you want that you should be given pension of superintendent.
superintendent, Lordship.
Show me, convince the court that this is permissible under the law.
Lordship,
Not understood.
Lordship,
Or understood, but you don't have the answer.
Lordship. Kindly, Lordship, my
The
dear.
prayer of learned counsel for the petitioner made with the consent of the others. Admission hearing of this matter stands adjourned for 4 weeks, list accordingly. You have to come prepared and argue the case as a
Lordship.
lawyer.
Sorry, Lord.
Correct, yes. Mr. So-and-so, who you are appearing for whom?
I'm appearing for the Proportion Department.
Your name?
Let's for RB Goswami for 1, 2 and 3, my lord.
Mr. R.B. Goswami, learned counsel is present for respondent numbers.
1, 2 and 3.
And Mr.
Actually, sir, my lord,
All right.
I was
that's all.
appearing on
Okay,
behalf of
next matter.
V Solo.
Huh?
I'm appearing on behalf of V Solo. Respondent 4 and 5.
We solo for respondent number 4.
Lordship, may I pray for fixing a date, Lordship? Petitioner is not
After 6 weeks.
not receiving a pension, Lordship. If
Huh?
his pension has been not given, Lordship.
Why?
Lordship, due to pending of the case. Lordship.
Appointment is irregular, my lord. He has not been appointed through a appointment process, my lord.
So now you are going to go into these things. Then why are you are asking promotion? They are saying your appointment is irregular.
Lordship.
What kind of case is this?
Well, the-
You better take some good proper advice from someone who understands service jurisprudence. Otherwise, you will be inviting more trouble for your client.
Lordship, Lordship.
You cannot file a writ petition where you want a direction that or declaration that your appointment is regular. You
Lordship,
should be paid pension and also you should be promoted with retrospective effect.
Lordship, my appointment has been received. Kindly, Lordship.
So have you issued any notification that his appointment is irregular?
My lord, we only came, we have, in our reply, we have found out what had happened, my lord, is they were appointed in 1991 as LDA in for muster roll workers, my lord. They then approached the court for regular appointment in 1994. However, my lord, the court had said that if till the regular advertisement is made, let them continue. Advertisement was published, they had appeared, they had submitted their applications, but they were never regularized. They were never appointed in those posts, my lord. Now that's why they're claiming that since from 1991 they were working, they're seeking regular appointment, promotion since
That
1991.
is the direction. They are
Lordship.
in the writ petition.
My lord,
Let me see.
that is a
Lordship, in my reply in Lordship, in page number. My affidavit reply, Lordship, page number 11, Lordship. And operative portion,
page
Lordship,
number 13, my lord.
operative portion, Lordship, page number 12. May I read? Consider.
What is this 28 August 2019 notification? Where is it? Let us see. Twenty-eighth of August 2019. Where is that notification?
Lordship.
My lord, it's at page number 33, my lord. It's the gradation list.
So where have you paid for pension?
Yeah, my lord.
Where is your prayer for payment of pension?
Lordship, I was Lordship in service, Lordship. After that, I filed pension, Lordship, another repetition, Lordship. 3182, Lordship, after retirement, Lordship.
Your understandings are good for you only, not for anybody else. Same for the states. If you haven't got pension, you file a writ petition, we'll consider. You can't say that decide it early so that I get pension. We may decide it after 5 years. You tell us what is your grievance. If you have not been paid pension, you have to file a petition and ask for that order. These kind of petitions will not be, we will decide cases when we think it is appropriate. If you want a relief, you ask for it. File a miscase pension or you file a writ petition.
Already, Lordship, after the retirement, Lordship, I have filed another repetition, Lordship, for pension, Lordship.
Where is it?
Lordship, 3182, Lordship, WPC 3182, Lordship.
WPC number.
3182, Lordship, 2022, Lordship.
This is the first thing you should have said.
Lordship.
Next matter.
Eight PG Lordship.
3182. 82, 2022.
Lordship, in this matter, on the last occasion, we were asked to file our affidavit. We have filed our affidavit today, Lordship. We've given them a copy, Lordship.
We need some time, Lordship. Go through it.
Affidavit on behalf of?
The respond number 1, Lordship.
For respond number 2 and 3, 2 weeks time may be given.
Mr. A. Pukul, learned Standing Council, GAD Assam, submits that in terms of the order of this court, affidavit on behalf of the respond number 1 has been filed today by serving advance copy upon the petitioner's counsel. Mr. C.S. Hazarika, learned Government Advocate Assam, also submits that 2 weeks time be granted for filing affidavit on behalf of respond numbers 2 and 3. Full stop. Mr.
R. Sharma.
R. Sharma, learned counsel for the petitioner, 3 weeks time to seek instruction and file rejoinder. In view of the above, let this matter be listed again after 4 weeks. In the meantime, parties to exchange pleadings.
Deeply
Okay,
obliged.
Lordship.
May I appeal, Your Lordship?
my lord, matter pertains to dismissal from service, my lord. They have filed affidavit, my lord. We have also filed our reply, my lord, but this is not on record, my lord. Our reply is not on record, my
Dismissal
lord.
from service. Where is the order?
My lord, my lord,
Where is the impugned order?
impugned order, my lord, page number 69, my lord. Disciplinary authority order, my lord.
They have otherwise challenged in the prayer, your lordship, they have challenged the inquiry report and appellate authority order and all that, your lordship. All the things have been challenged, your lordship.
Illicit opium recovered from the Dekki.
Yes, my lord.
Any NDPS case?
Lordship, one is continuing. Lordship. Proceeding, my lord. That is one of the grounds actually, your lordship, that one is continuing and that is why.
The proceeding is, my lord, is going on, my lord. Yes, already granted bail.
Narcotics case number 01/CL, page number 9, para 9, page 3 of our affidavit, your lordship.
So what is the ground of challenge?
The challenge, my lord, basically, my lord, cross examination was denied. Defense assistant was not offered, my lord. This, my lord, come down.
Nothing. We'll hear it, issue rule and hear it, post it for hearing after summer vacation.
Affidavit is also not record, my lord, our reply, my lord. Then maybe affidavit is filed, my lord, 28.
Right, Mr. So-and-so learned counsel, Mr.
D. Govil.
D. Govil and counsel for the petitioner submits that the rejoinder affidavit filed on behalf of the writ petitioner in this case is not on record. Mr. C.S. Hazarika, learned government advocate Assam is present on behalf of the official respondents. In view of the above, let this matter be listed again after 3 weeks by tagging the affidavit, rejoinder affidavit with the record.
Highly obliged.
May I please your lordship?
Hmm.
My senior is legs on another court. Kindly matter may pass over for the time being, lordship.
Time being, what matter? You argue. What is this matter about?
Here we have challenged the selection process, lordship, of Gaubura. But the appointment was already done, lordship,
Appointment already done.
already done.
File appeal. Statutory appeal.
Lordship, kindly give a direction.
Yes, what do you say? What is it?
Dispose of in the earlier terms. Yep, they have not filed appeal lordship yet.
Challenge the appointment of respondent number 7.
Yes, lordship.
So your name please, Miss
Ardas.
Miss Ardas, learned counsel is appeared for the petitioner.
Lordship, I am appearing for respondent number 7, lordship.
As Datta, learned SC Revenue Department Assam has appeared on behalf of respondent numbers
1.
Respondent number 1, Miss A. Talukdar, learned government advocate Assam. So respondent numbers 1 to 6 and Miss
S.E. Ahmed. S.E. Ahmed.
S.C. Ahmed, learned counsel for respondent number 7. By filing this writ petition, the petitioner has challenged the selection and appointment of respondent number 7 as the Gao Pradhan of which village? Gao Pradhan of which village?
Yes. They have not.
Chauni village, lordship, district Nagaon, Assam.
Gao Pradhan of which village?
Chauni.
Where is the select list? Nobody knows anything.
Select list
Selection.
26 page. Page number 26. Serial number 13. Lordship.
In respect of Gaon Pradhan of number 8 dash Jauni village of Gakhir Khaiti 1 and 2 in the district of Nagaon
Koliapur Revenue Circle.
under the Koliabur Revenue Circle in the district of Nagaon on the ground that the petitioner did not fulfill. The petitioner did not meet the eligibility condition laid down in the advertisement notice dated 29/2021. Full stop. It appears from the submissions made at the bar that the appointment that appointment order in respect to the respondent number 7 has already been issued and he is functioning as a Baugura. Full stop. At this stage, Mr. Datta Lanet, SC Revenue submits that in a number of similar cases, this court has directed the aggrieved party to prefer appeal under Rule 162 bracket C bracket close of the executive instructions framed under the provisions of Assam Land and Revenue Regulation 1886, and therefore a similar order be passed in this case as well. First up, this case as well, since the issue raised in the writ petition involves disputed questions of facts. First up, the petitioner's counsel has not been able to furnish any reason as to why the submission of learned department counsel should not be accepted by this court. In view of the above, this writ petition stands disposed of by granting liberty to the petitioner to prefer an appeal under Rule 162 bracket 2 of the executive instructions before the jurisdictional divisional commissioner. Full stop. If such an appeal is preferred within 2 weeks from today by enclosing a certified copy of this order, then the same, along with proper explanation for delay, then the same be looked into and disposed of by as a reasoned order within the time frame provided by the statute. With the above observation, writ petition stands closed.
May it please your lordship. Well, so far as the filling of the post of Anganwadi workers are concerned, there's a notification from the Ministry of Women and Child Development at page 21, which says in substance that 25% posts through promotion from helper to worker. Now 20 posts fell vacant. The details at page 9, my lord, upon the earlier workers having gone on superannuation. And they issued 2 notifications on the 7th, on the 8th and 18th of July, whereby they proceed to fill up 12 posts by way of promotion. We say it exceeds the 25% quota. They ought to have filled up 5 posts by way of promotion and not 12 posts. That was our case.
Where is the advertisement?
Page 13 and 18. May I read? It is hereby invited application from the helper in continuous service as per the below noted terms and conditions for the vacant post of Anganwadi workers mentioned against Anganwadi Center under Gauripur ICDS project. Applications accepted at the below mentioned office on so and so at so and so. No application will be accepted beyond the time specified. This indicates 12 posts.
Yes, what do you have to say, Mr. Nath?
We have filed our affidavit. All these posts, implementation of the Anganwadi ICDS project, although funded by the central government, the duty for implementation is on the state. But the state government has already issued a notification on 4th of March 2013. We have annexed at page 37, one of the annexure F. But by this notification, an opportunity has been given to the working helper for an upgradation. There is no question of promotion, it is upgradation, opportunity of upgradation is given to them if subject to fulfillment of the conditions, if they are serving for last 10 years continuously, along with other educational qualification or all these things. But this position has already been clarified in the case of by the Honorable Apex Court, in the case of State of West Bengal versus Kaveri Khastagir, they reported in 2009 3 SCC page 68 and 2009 3 SCC page 68. But here court has held that all the aforesaid rules promulgated by the state government under paragraph 47 of the Integrated Child Development Scheme leaves little room for doubt that the respondent number 1, 2, and 3 and the others similarly situated were in fact state government employees. Learned single judge as well as the division bench of the High Court appear to have been swayed by the submissions made on behalf of the respondent number 1, 2, and 3 that the state of West Bengal is merely a nodal agency to supervise the implementation of the scheme, which was in nature of a project, and that the employees thereunder were therefore project employees overlooking the overall intention and object of the scheme, that in order to provide child care and nutrition for children and lactating mother, the central government was willing to fund the entire project but left the implementation thereof to the state government, who were authorized under the scheme to appoint the staff of the project who were to be born on the appropriate cadre of the states. Paragraph 35 of the scheme, which deals with the function and responsibilities, makes this provision very clear. But the entire implementation of this scheme, how to appoint the persons for implementation, workers and these Anganwadi helpers, it is left to the state, and accordingly this notification has been issued by the government. And since 2013, before that there was another notification, but from 4th of March 2013, this is being followed for upgradation of the in-service Anganwadi helpers to the Anganwadi, to the post of Anganwadi workers. But the system in force provides that wherever due to some reason the post of Anganwadi worker is fallen vacant, then if the Anganwadi helper is eligible, as per this notification,
Just a minute, Mr. Banik, is it the case of your client that she was eligible for being promoted?
No,
Then
it is our case that in terms of the 2006 notification, that page 21, which says by the ministry that worker to helper, helper to worker, there will be 25%. Only the post would be filled out by promotion. May I read page 21, the third paragraph? While we have been concerned about providing some opportunities of further growth to Anganwadi workers, it was never thought of the Anganwadi helpers in the same way. It has therefore been felt that some opportunities, as in the case of Anganwadi workers, should also be given to the Anganwadi helpers to motivate them to discharge their functions efficiently. Accordingly, a decision has been taken to reserve 25% posts of Anganwadi workers to be filled up from amongst Anganwadi helpers who have put in minimum 10 years of satisfactory service and also possess the requisite qualifications, age, education, etc., as laid down by the concerned state government, Union Territories administration for selection of Anganwadi workers. This will apply in respect of all existing vacancies of Anganwadi workers and new vacancies arising out in the future in the newly sanctioned Anganwadi centers. The guidelines issued by the ministry in the past that Anganwadi workers and Anganwadi helpers should be from the same village would, however, have to be adhered to while giving effect to this new policy initiative. States, Union Territories are therefore requested to give suitable instruction to all the authorities concerned with the implementation of ICDS scheme in the state, Union Territories to strictly follow the above guidelines in selecting the Anganwadi workers. In context and in furtherance of this, the notification at page 22, which my friend is relying to, has been issued.
4th March 2013 is in context
So
with
are
the
you
promotion.
challenging this notification?
No, we are in support of it. We say 25% by promotion, and how you would promote is 4th of March 2013. It does not say that direct recruitment has been banned. It is in essence the 2006 observations of the ministry that 25% has to be filled up by promotion is what is 4th March 2013. May I read? It is not said that direct recruitment is not there. That is not even the case on
What is this
affidavit.
8722 and 18722?
8722 and 18722 are notifications by which they seek to fill 12 and 7 posts respectively out of 20 vacancies. We say 25% of 20 would be 5, fill up 5 by promotion, the rest open to direct recruitment, which we are eligible. If you take 17, that's more than 25, then our chances are gone. In affidavit, they have not taken this stand. Their particular stand is that I do not qualify for promotion, need not. I need not apply for promotion even.
Where is this 8722 and?
Page 12 and page 13 and page 18.
In our
13.
affidavit, page 20, annexure A and annexure B. Malad.
Of the writ petition 13. 13 and 18. May I? It is hereby invited application from the helper in continuous service as per the below noted terms and conditions from the vacant post of Anganwadi workers mentioned against the Anganwadi Center under Gauripur's Child Development Project. Applications accepted, below notice, so and so, so and so. No application. Here it is.
So, Mr. Banik, you are saying that they are, by this advertisement, they are exceeding the quota of
Lordship.
25%. When it happens, and if you get dropped because of that, then we'll decide the matter. Today, we'll
There,
not do it.
initially, there was an interim order by this honorable court saying that it should not be filled up. Subsequently, by another order, the advertisement was stayed. Eventually, by an order of your lordship, the last order, which says that in the earlier interim order to continue, and even if they have filled up, it would be until the subject matter of further orders of this court. And I'm told, my colleague has told me, informed me that the post against which we are claiming, or we would apply rather, has been filled up despite there being protective orders of this court. True, we have not filed a contempt.
Like here only one petitioner is there. She is aspirant of for the direct recruitment. Malad. She is not in service, and she is challenging the notification. In fact, notification has not been, although submissions have been made, it is not directly challenged. Now the advertisement challenge, which is for the in-service Anganwadi helpers. She has no locus to challenge this law. She is not in service law.
But if you're exceeding the 25% quota.
Malad, as per this notification provides an opportunity for the in-service helper for an upgradation. Malad. This doesn't say the percentage. Well, the state government is authorized to issue this notification, and this is being followed from 2013. And the otherwise, the after, if the eligible Anganwadi worker
This
helpers are not there.
25% quota is by the central government.
The central government later was in 2006. Thereafter, kindly similar, this 2004 of March 2013 was issued in modification of 1/3/2013. So this is the latest notification which is followed by the department for upgradation of the helpers. Well, after this advertisement where these posts are shown for the filling up the post of Anganwadi workers, there for some reason for retirement or any reason, those posts fallen vacant in the meantime. But because of that, by following this notification, they want to give an opportunity to the in-service workers. And kindly see, here, one clause is there. If Lordship is holding that notification at page 37 in the affidavit, but only those Anganwadi helpers shall be eligible for promotion under the scheme who have been in continuous service for a period of 10 years and above as Anganwadi helpers in any duly sanctioned Anganwadi center. And kindly see, for appointment of Anganwadi worker and helper, the condition prescribed is that the Anganwadi helper or worker should be from that particular survey area of that center. But here some relaxation has been given. Kindly come to clause 9.
Mr. Nath, the only question is what will be the percentage? Direct recruitment, how much? Promotion, how much?
No,
What is?
no, but there is no concept of promotion. as my lord, they are not holding any government post.
What will be the total number of quota for direct recruitment?
My lord, direct, whenever vacancy arose, my lord, if the Anganwadi eligible Anganwadi helpers are not available, then it will be direct for my lord, open from open market. These are honorarium service, my lord, under the particular scheme.
Where is that decision?
My lord, the scheme is very, my lord, kindly see, this scheme is very, notification is clear, my lord.
Please get us the record where you have taken this decision. It can't be completely arbitrary. You have to first decide how many. See, you are taking Anganwadi workers from two sources. One is upgradation, promotion, whatever you call it. It's the same thing. And another is direct. Correct.
Whenever my lord, a center is established, we need two persons to run the center, Anganwadi worker and helper. But if the worker is not there, we have to, for that initial stage, my lord, we have to issue the advertisement from the local candidates of the survey area. But if the Anganwadi worker left the job or she retires or died, then if the post is fallen vacant, then the helper gets the first opportunity that if she is eligible, she will be given the opportunity to upgrade.
So where is that? Where is that?
This is the notification, my lord. This is the notification. Kindly see, my lord. Therefore, I am referring to clause 9 of that notification. Clause 9. Kindly see. The scope has been little widened here. Kindly see.
Yes.
The promotion shall remain confined to the Anganwadi centers of the same revenue village. Otherwise, my lord, for the initial entry, it is only the survey area of that particular center. Now it has been extended to the revenue village. In a revenue village, there may be 3 or 4 Anganwadi centers. The promotion shall be remain confined to the Anganwadi centers of the same revenue village, and as such, an Anganwadi helper of one revenue village or ward of a municipality or town committee cannot apply for promotion in the post that arises in center falling in different revenue village or ward or municipality or town committee. So if two under a revenue village, 3 Anganwadi centers are there. In one of the Anganwadi center worker post is fallen vacant, the Anganwadi helper of the other center also can apply for that upgradation. This is the opportunity particularly given to the Anganwadi helpers.
All right, now tell me, these advertisements have been stayed.
Lordship.
Then how they've completed this recruitment process?
No, my lord, that of course, my lord, I have to take the instruction, my lord. Possibly.
There is an order of 19/12/2020, which has stayed the advertisements.
My lord, that my lord, I
All right, how
I have heard the submission,
Senate
but
Council
I'll take the instruction on that.
to submit that notwithstanding the interim order passed on 19/12/2022 as extended by order dated 23/1/2023. The respondents have suspending the operation of the advertisement notice dated
8/7 and 18/7.
7/2022 and 18/7/2022. The respondents have gone ahead with the recruitment process and have also notified the select list. Therefore, it is a clear case of contempt of court. Mr. D. Nath Lanet, Senior Government Advocate Assam, appearing for the state, prays for 2 weeks' time to obtain clarificatory instruction and place the same before this court. In view of the above, this matter stands adjourned for 2 weeks, list accordingly. Let us see. If it is in violation of the court's order, you withdraw it or you face the consequence.
I'll take that instruction. Otherwise, my lord, the stalling the entire process. These are, my lord, at the grassroots level for implementation of the ICDS project.
That's correct, but there is an order of the court.
True, my lord. I have to take that instruction. I'll take it.
My pleasure, Lordship. Well, the DP was kept pending, my lord, since 2018. As per last order, my lord, they were supposed to complete the process and submit status report, my lord. That hasn't been done, my lord.
Lordship, that's still awaited, Lordship. The present status of the DP is still awaited, Lordship. And the present status, Lordship, about the DP, Lordship.
It was initiated when?
2018.
Where is the order initiating the DP memorandum?
My lord. Page 53, my lord.
Your client is still serving.
Lordship.
Client is still in office.
Yes.
Serving as what?
The deputy director employment, my lord.
All right, within 3 months from today, conclude the DP. That will dispose of the matter. Heard Mr. R. Chakraborty, learned counsel appearing for the read petitioner, also heard Ms. A. Talukdar, learned government advocate Assam appearing for all the respondents.
1, 2, 3, 4.
1, 2, 3, 4. Mr. The petitioner hearing is serving as serving as what?
Deputy Director, my lord, employment
Director in the
and
Directorate
craftsman
of
training.
Employment and Craftsmen's Training, Rehavari. Full stop. While discharging her duties as aforesaid by the memorandum dated 13/5/2019, a departmental proceeding was instituted against the petitioner. Full stop. The primary grievance of the petitioner is that despite the lapse of nearly 4 years, the departmental proceeding has not made any progress. Full stop. However, due to the pendency of the departmental proceeding, the petitioner has been made to suffer serious prejudice. Full stop. After taking note of the submission made by learned counsel for the petitioner, this court had passed order dated 13/3/2023, asking the learned government advocate Assam to obtain instruction as to the reason for delay in conclusion of the departmental proceeding. Thereafter, time was granted to the departmental council again on 21/3/2023 to obtain instruction. However, when the matter was called up today, the learned government advocate Assam submits that there is no instruction. Submits that instructions are still awaited. Full stop. It is settled law that undue delay in conclusion of departmental inquiry infringes upon the rights of the public servant, thereby causing serious prejudice to his or interest in the matter. Full stop. Unless there are genuine and bona fide reasons to prolong the departmental proceeding, the same ought to be concluded as expeditiously as possible. Full stop. In the present case, despite having granted opportunity to the learned departmental council, no reason whatsoever could be cited for the reason for delay in conclusion of the departmental proceeding. Full stop, As a matter of fact, the learned government advocate has also not been able to appraise this court as to whether any progress has been made in the departmental proceeding. Be that as it may, considering the facts and circumstances of the case,
It's in the evidence stage, Lordship. It's in the evidence stage,
this
Lordship.
petition stands disposed of with a direction upon the respondents to conclude the departmental proceeding initiated against the petitioner within a period of 3 months from today. Full stop. The petitioner to produce a certified copy of this order before the competent authority within a week from today. If the departmental proceeding is not concluded within 3 months as directed by this court, the petitioner would be at liberty to approach this court once again seeking appropriate remedy in the matter. The petition stands closed.
My lord, may I refer just one clause, because it is departmental manual of departmental proceeding, my lord, clause 3.13, which says, my lord, recording of evidence has to be completed within 2 months. Here in this case, my lord, this pending since 2019.
That's right. So for now, 3 more months, let them conclude it. Otherwise, you come, we'll squash it. We'll stay and quash it.
Always.
Obliged, Lordship.
In this matter, my lord, I have already prepared the affidavit and sent it for vetting, my lord. Further 2 weeks time, my lord.
Heard Mr. Ayed Sekal and Council. Also heard Mr. H. Das, Learned Standing Council, GHC, preparing for the respondent numbers 2 and 3 to submit them. The affidavit is ready and has been sent for vetting. Therefore, 2 weeks time be granted for bringing the same on record. Prayer allowed. List this case again after 3 weeks. In the meantime, affidavit be brought on record.
Highly.
But Lordship may grant me some time for filing the affidavit.
Learned counsel for the petitioner is present. Mr. D. Nath, Learned Senior Government Advocate Assam, prays for and is granted 3 weeks further.
Lordship, only one week, last occasion they had submitted that
Yes,
affidavit is already ready, Lordship.
Maybe your lordship. This is regarding Gram Pradhan, the last of my series, by the way. Your lordship has passed earlier orders giving liberty to file appeal. And notice, while issuing notice, my lord, may I place one of those orders?
Now present series.
My lord.
So what is to be done here?
My lord, notice may be issued and my lord,
Notice may be issued.
no, this can be disposed of in the light of your lordship's earlier orders, my lord, in many cases.
Already appointment has been made.
No, my lord. To my knowledge, my lord, no appointment. My learned friend will know better.
Statutory appeal,
Yes, Lordship.
you are appearing for?
That's one number 3, Lordship. Private appointment.
Take down heard Mr. L. P. Chaudhary, Learned Senior Counsel, assisted by Mr. P. Bharojbhai, Learned Counsel for the writ petitioner. Also heard Mr. S. Datta, Learned Standing Counsel, Revenue and Disaster Management Department, Assam.
For respondent number 1.
Appeal for the respondent number 1. Mr. R. Dhar, Learned Government Advocate, Assam, for respondent number 2, and Mr. S. Alam, Learned Counsel for respondent number 3. First of all, by filing his writ petition, the petitioner has challenged the selection of respondent number 3 for appointment in the post of Gram Pradhan in respect of 6 number Telia Sapori under Khatwal Morja. Telia Sapori village,
Yes,
is
yes.
Telia Sapori. Telia Sapori village under Khatwal Morja of Samaguri Revenue Circle in the district of Nagaon, primarily on the ground that being an active member of a political party, the respondent number 3 did not have the eligibility under the advertisement notice dated 05/09/2022 to participate in the selection process. Full stop. After taking note of the grievance expressed in the writ petition, this court had passed an order on 20/3/2023, restraining the authorities from issuing the order of appointment in favor of the respondent number 3 without proper verification of his antecedents, including his eligibility to be appointed as a Gram Pradhan under the advertisement notice dated 05/09/2022. Accordingly, no order of appointment has been issued in favor of the respondent number 3 till today. First up, Mr. Datta submits that since the allegation made in the writ petition would require verification of disputed questions of facts, the petitioner be directed to refer an appeal under Rule 162.
C.
Huh?
162C.
162 bracket C bracket close of the executive instructions framed under the Assam Land and Revenue Regulation, 1881,
86.
sorry, 1886. But since similar orders have been passed by this court in a series of other matters, Mr. The learned counsel for the petitioner has also agreed to such a recourse. In view of the above, this writ petition stands disposed of by granting a week's time to the petitioner to prefer an appeal under Rule 162 bracket C bracket close before the jurisdictional divisional commissioner by enclosing a copy of this order. If such an appeal is filed, the same be considered on merit and disposed of by a reasoned order within a further period of 60 days. Full stop. Until disposal of the appeal preferred by the petitioner, the interim order dated 23/2023 passed in this proceeding will continue to hold the field.
Therefore, no interim order or sparse lordship, only there is observation regarding vindication lordship. That may be. Yes, that is what. Yes.
Obliged, fine. Okay.
May lordship. Now, this matter relates to the appointment of the competition of ground measure. But the DRC initially rejected the implement of petitioner.
It's like 2005, you
Yes.
know the order. You can take 5 minutes, but I'll dictate the order.
Lordship may kindly see the last
2005 is not
rejection.
possible.
Last rejection, Lordship may kindly see that.
Last rejection. This is wrong. Several times the matters have been sent back. This was very wrong on the litigant. Very wrong. He was given a wrong picture. Who is responsible? I am not going into the details. Very, very wrong. Question doesn't arise. 2005, father died. Today, mandamus for compassionate appointment?
No, I'm praying for
Question doesn't
mandamus. I'm not praying for mandamus. I'm just praying that under 2015 notification, they may reconsider my case.
My lord, the thing is that when his father died, he was only 11 years old. Immediately, my lord, he has filed in 2017. My lord, that he cannot, my lord.
Right, heard Mr. Ayed Sekhar, learned counsel for the petitioner.
But in that case, I'll withdraw that.
You will
I'll withdraw the petition.
withdraw. Let these things come to an end, huh? Don't turn this High Court's platform into this.
But the reason in the in order, they have said that due to lack of vacancy in the particular department, they have
The
rejected.
order of this court is you cannot consider these applications. That's all. And that order will be now binding on everybody. It cannot be done. 2005, 1998, 1990, you are ruining the lives of these people by giving them hope of orders and appointment. How can a compassionate appointment be made after 30 years, after 25 years? Please read the scheme document once and see what
Yes,
they are
yes.
trying to do.
That is true.
Then why are you filing these cases?
This petition was filed.
Only to be
because-
dismissed, you want an order of the court, judge, relief-oriented judge, reconsider, they'll again send back, again you file, again reconsider. That is the
It
business
was-
going.
it was rejected in 2020.
Mr. Ayed Sekhar, learned counsel for the writ petitioner 6. Leave of this court to withdraw this writ petition. The prayer is not of Mr. Ardhan. Learned, you are appearing for
My lord, I'm appearing for 3, my lord.
government or department?
No, government, my lord.
Government or some. And.
PNRD, my lord, P handling one,
PND for
two
one,
and four.
1, 2, and 4. Arrange it. We do not have any objection with the prayer. In view of the above, writ petition is disposed of.
In this case,
No liberty,
in
my
fact, in fact, I personally suggested the client not to file this petition. And for this filing this petition, I have also not taken any fees because I told you.
No, that's the different thing. Don't get into all this stuff. We are not on who is taking fees or who is not.
I
You see,
told him.
when a petition is not maintainable
Yes.
and in matters of employment, these petitions create a false hope in the mind of the people. And it attracts more petitions. But the simple matter is that within 1 year or maximum 2 years,
Yes.
over. After that, no question of compassionate appointment.
Yes.
This is not a right. This is just a compassion. How can there be compassion on a person after 30 years?
Obligation.
It will be orders.
My lord, by order dated 8/5/2023, the Honorable Court passed an order to apprise the court why we could not promote the petitioner from grade scale 3 to grade scale 4. My lord, I understand there is some predicament so far the petitioner's counsel is concerned. Because the person is retiring on in the next month. So therefore, my lord, I am praying for just a short time so that I can, my lord, apprise your lordships the precise reason for not considering his case. Can it be fixed on 29/5? My lord?
29/5 is a fixed item.
My lord.
Mr. S. Chakravarti, learned counsel is present on behalf of the petitioner. Mr. A.S. Datta, learned senior counsel, assisted by Ms.
S. Musahari.
S. Musahari, appearing for respondent numbers 1, 2, and 3, seeks posting of this matter again on 29/5/2023. So as to complete his instruction and appraise this court as to why the case of the petitioner was not considered for promotion
Much of
to the scale
Four.
4.
scale 4. From
Scale
scale
four
3
rank.
to scale 4.
From scale 3, Roman 3 to scale 4 rank.
God bless you.
List accordingly.
This case, my lord, the petitioner, if your lordship is a wife, my lord, of the original petitioner, my lord, who died during the pendency of this case, my lord. So disciplinary proceeding of propriety of the order was challenged, my lord, it is compulsory retired. But, I'm praying for substitution of his wife, my lord, as a petitioner.
Disciplinary proceeding is a personal matter. What
No, my lord,
proceeding is still going?
no, the proceeding did not take place, my lord. Without any show cause, he was dismissed from service. The propriety was challenged, my lord. Compulsory retirement order was passed. My lord, without initiating any proceeding whatsoever. Even no show cause was issued, my lord. Even the complaint on the basis of which he was dismissed, my lord, that also not even served on him, my lord.
But the problem is, if you succeed, then what? Who will be reinstated? Wife?
No, the reinstatement. No, she will get the benefits, my lord. Salary, other things, my lord. Retirement benefits, etc.
I have no objection for substitution, but he has two sons also. That has not been narrated as a party also.
My lord, then in my understanding, my lord, since it's a question of.
What is the law? Tell me. Forget your understanding.
My lord,
my-
normally, my lord, then I'll be filing a fresh petition, my lord.
Mr. M. Datta, learned counsel for the applicant, seeks leave of this court to withdraw this IA so as to file a fresh application for implement of all the legal heirs of the deceased employee. Mr. S.C. Kyle, learned counsel for the
Assam University.
Assam University is present and does not have any objection to the prayer is allowed. IA stands disposed of on withdrawal with liberty.
My lord, deep love, my lord. This order, my lord, has remained, my lord, uncomplied for a long time, my lord. The pensionary benefits, my lord.
No, in this matter, I need some more time, my lord, because up to date instruction is required. My lord.
Who is the person to comply? Call him, let him be present Friday.
My lord, actually, earlier officers, they are not present holding my. And on request of the court, I am appearing and trying to solve the matter, my lord.
But then you give it up. Will be direct personal appearance. They are not doing a favor by complying with the court's order.
My lord, may I submit the last instruction, my lord?
I am posting it day after tomorrow. Give me the name of the officers. I'll pass an order for that.
But lordship may kindly, what's
No,
my
no,
lord?
no. This order is,
Because
what is the date of this order?
23/11/15, man.
Heard Mr. M. Datta, learned counsel for the petitioner, also heard Mr. S. Datta, learned standing counsel PNRD Assam, on whose request this matter is posted again. This matter is to be listed again day after tomorrow, so as to enable him to furnish the names of the officers, names and designations of the officers who are responsible for non-compliance of the court's order, so as to enable this court to pass appropriate order in the contempt proceeding.
My lord.
Give it in writing.
Yes, yes,
We are directing their personal appearance.
my lord, my lord,
Same day.
my lord.
Day after tomorrow only we'll direct their personal.
Obliged.
And tell them that this is the order which is.
My
coming.
lord, my lord.
What is this IA for? Now appears for the applicant. His IA has been filed with a prayer to implead the incumbent in the office of Deputy Commissioner Hailakandi on the ground that the named officer is responsible for implementation of the court's order. However, it is available in public domain that the officer concerned is no longer the Deputy Commissioner of Hailakandi. In view of the above, these IA stands disposed of as infractions with liberty to the applicant to file appropriate application for implement if so advised.
May I please, your lordship? No, please. Lordship, I'm appearing for the responding 1 to 5, lordship. Lordship, we have filed wakalatnama today. Some time may be given to file affidavit.
Lordship, notice has been completed to 1 to 5, he's appearing. Lordship, but for respondent number 6, we have served notice, but it has not been completed.
So what do you want to do? Fresh steps?
Yes, Lordship.
All right. Heard Miss
G. Swami.
G. Swami, learned counsel for the petitioner. Also heard Mr.
Why Borbuya?
Y. Borbuya, learned counsel, who submits that by filing wakalatnama, he along with his your senior, who is your senior?
Mr. H. Gupta.
Mr.
H. Gupta.
H. Gupta have entered appearance on behalf of respondent numbers 1 to 5 and therefore be given 3 weeks time to obtain instruction.
Lordship, they were appearing on the last date also, on 22/6/2022. They haven't filed their affidavit yet and not the wakalatnama.
You have not filed wakalatnama.
That's some instructions for remaining, then we have engaged.
Right. Mr. Soso Borbuya submits that he has
Lordship.
instructions to appear in this case on behalf of respondent numbers 1 to 5. And therefore a wakalatnama will be filed very it will be filed shortly.
Lordship, a date may be fixed.
Ms. Swami, on the other hand, seeks leave of this court to take fresh steps for service of notice upon respondent number 6. Leave granted, steps be taken within 3 days from today by registered
Yes,
post
Lordship.
with AD, making the notice returnable on 19th of June 26th of June 2023. Release this case again on 26th June 2023 by reflecting the name of counsel appearing for both the sides.
Obliged.
May it please, my lord. My lord, in this matter, my instructions are that the compliance affidavit has been filed in a contempt petition. And my lord, in this matter, the petition may be taken up for hearing on the next date, my lord.
Where is the affidavit? You have received copy.
Lordship, this IA, one IA I have received, lordships, another, there are two IAs, 2594 of 2022, that is not received by me, lordships.
You have filed affidavit in which case?
My lord, in the contempt case, my lord, Kushal Samwa. It's filed on 25/8.
Mr. A. Borua, learned counsel for the
APDCL.
APDCL submits that a compliance affidavit has been filed in contempt case number 603/2020 on
25/8/2022.
25/8/2022. However, it appears that the affidavit is not tagged with the record of the case. Mr. Sharma has also submitted that no copy has been served upon him. In view of the above, registry to list this case again by tagging the affidavit with the record of contempt case number 603/2020. A copy of the affidavit be furnished to Mr. R. Sharma within a week from today.
I'm obliged, my lord.
One more matter.
Instruction is awaited, my lord, regarding corporation appointment. They have come after 22 years. Yes,
Corporation
further on 2002.
Heard Mr. Your name, please?
Why Borbuya?
Why Borbuya, learned counsel for the petitioner. Also heard Mr. S. Bora, learned the standing counsel GFC.
BTC, lordship, BTC.
SC BTC, who prays for it, is granted 4 weeks further time to obtain instruction in the matter. Ms. DS Neogi, learned standing counsel. Ms.
Me কাকে না?
Irrigation department, your lordship.
And standing counsel election department is also present.
We have not received copy, your lordship.
And submits that no copy has been served upon the petitioner's counsel to furnish copy.
Publish.
Yes.
I have been instructed to appear on behalf of the sole respondent, my lord. I will file my affidavit, my lord, and file my power. also.
Lordship, here in the present case, the petitioner did not get his pension amount, lordship. So then the petition was filed, the petition was disposed of, giving direction to release the money within a month. They have violated, then this contemporary. His wife is very serious, lordship. Both kidneys have been damaged. Page 37, lordship. She is surviving on oxygen. So immediately she has to be taken to Vedanta Hospital for kidney replacement. But I don't have the money to hire air ambulance, lordship. Commissioner has approved the payment, but the accountant is not releasing the fine. This
I
lasts
don't
more
have
than
the
1 month.
instruction, my lord.
Day after tomorrow, you get the instruction.
Lordship.
Heard Mr. S.P. Royal on a counsel appearing for the petition. Also heard Mr. S. Bora, learned counsel, who has entered appearance on behalf of respondent number 3 and prays for time till 24/5/2023 to obtain instruction. Since it is submitted at the bar that the wife of the petitioner is critically ill and is required to immediately undergo a kidney transplant operation at New Delhi, resulting into urgent need of monetary support. Mr. Bora to obtain instruction in this case. And appraise this court as to why the pension of the petitioner has not been released till today. A copy of this order be furnished to Mr. Bora during the course of the day. List
Obliged.
accordingly.
Wait, please, Your Lordship. The order from which the contempt petition arises starts at page number 11, my lord. And page number 13 is the relevant portion, my lord.
Mr. A.K. Borua, learned counsel for the petitioner, Bhagya Singh eligible. How many contemners?
My lord, total 5, my lord.
Total 5, 8 weeks. That's the registered post. Baki, you know how to do it.
Obliged. Deep.
Every willful disobedience and negative devotion of cost of loss. Yes.
Obliged.
Made the lordship. Well, item 58 and 60, lordship may dispose of directing the commissioner law some revision, my lord, to dispose of the appeal. Item 58 and 60. And
But
with
his
respect of item
petition is
59,
liable to be dismissed because he was not eligible to apply. He could not complete the age bar. Minimum age was 30 years. He was short of 30 years.
my lord, then my lord, lordship may invoke the jurisdiction of writ of quo warranto, because my lord, he is also not qualified. He is also not qualified,
Let us do it in a sober manner.
my lord. That is what I am,
What is, what is your case? It has come for what orders?
yes.
The IA has been listed or?
IA has been listed in the next case. I have filed a IA because there is an interim order there. Here, there is no interim order.
You are appearing in which case?
60, item 60.
Item 60. Two writ petitions, 195 and 1004.
So give me 195 first. Writ petition 195.
I will note to those. 195, your lordship pleased to see the order dated, initial order dated 18/1/2023.
One 195, my lord, I have challenged the corrigendum by which, my lord, the rule has been amended. The executive instruction has been amended in writ petition number 195. Because, my lord, Here is no mention as regards the upper age limit also. And the advertisement says the upper age limit is 65. And the 65 is itself is a retirement age in respect of the post of Gaon Pradhan. And I am working as Gaon Pradhan since last 5 years, my lord, as in charge Gaon Pradhan.
So in this writ petition, you are only challenging the corrigendum.
Corrigendum, my lord.
Where is it?
Page 43, my lord.
So what is the effect of this corrigendum? What is the age, minimum age?
Now, Malad, it has been reduced to Malad. Initially, it was Malad 35, then it was reduced to 25. Now it has been Malad again Malad enhanced to 30. 30.
So this is not the last one. After that, another corrigendum has come.
No, but after this Malad, no corrigendum has come. After 27.
2710 is the last mistake.
So this says 25 years.
No, that's
It's very complicated one.
Very complicated, Lordship.
Huh?
This is very complicated. That has to be read with earlier notification, Lordship, 2021, Lordship.
This 30 is the earlier notification.
Yes.
First, take up page 43, Lordship. Please read the line number 3, 25 years in place of 35 years, pertaining to serial number 3 to relate. 3 relating to amendment in executive instruction number 162 appeared in notification number so dated 26/8/2021. Then Lordship, see the earlier notification 2021 itself. Page 28.
So this will segregate and issue rule and hear it in due course.
Yes,
There
but
is no
here,
question.
here, my lord,
Interim order is there.
in 195, they have also, he has also challenged my lord, selection process.
That part, Lordship has granted liberty. Initially, I challenged the selection as well as the corrigendum. Lordship was of the view that he has the liberty to challenge the corrigendum, but the selection part he have to file appeal before the commissioner. Accordingly, I have filed appeal before the commissioner, Lower Assam Division. Thereafter, appeal was not taken up. That's why the second writ petition, my lord.
Why appeal was not taken up?
I don't know, till that they have not taken any action on the appeal, my lord. Appeal was preferred one, my lord.
Immediately thereafter. on
19/1/2023.
So is there any stay order in WPC 195?
Yes.
No, there is no stay order.
In 195, there is no
What
stay
is
order.
the,
In 195, there is no stay order. my
So
lord.
you just said yes.
No, I'm sorry, my lord. In the other writ petition, it is there.
Take down, heard Mr. IHC Learned Council appearing for the writ petitioner, also heard Mr. S. Dutta Learned.
Instead of issuing rule, my lord,
Learned,
take up the matter. Instead of issuing rule, my lord, take up this matter for admission, my lord, after filing the appeal.
We are we are coming up with a resolution. There will be no hearing from now onwards. Everything will be decided in admission, but admission after 5 years. Nobody wants hearing. And we will scrap it, no hearing. Admission for final disposal, which will be worse than hearing. So, what is the urgency here? Why? Because your client is shouting at you. That's why.
Otherwise, he is not eligible, Lordship.
Otherwise, why rule should not be issued in this case?
If the pleadings are
No,
accepted.
no, what is the urgency in this case? Tell me.
Urgency is that, my lord, he is holding.
He'll quickly get an order, get everything set aside, become a Gaon Pradhan, and then go to his village and.
He was working as
Tell
Gav
him.
Pradhan, my lord. His father was also Gav Pradhan. He's still working as Gav Pradhan, my lord.
So and so also heard Mr. S. Dutta, Leonard Standing Council Revenue Department, Assam. Appearing for the official respondent, Mr. B.C. Das, Leonard Senior Council.
S.H. Raman.
Mr. S.H. Raman has appeared on behalf of the private.
Respondent number 5.
Paper number 5. It appears from the submission of learned counsel for both the sides that the corriendum dated 27/10/2022 altering the age limit for entry in the post of Gav Pradhan is under challenge in the present writ petition. First up, the aforesaid issue cannot be decided in the absence of stand of the department being brought on record in the form of an affidavit. First up, considering the nature of issue involved in this case, this writ petition be now segregated from WPC number 1004/2023, and the matter be listed separately for admission hearing after 6 weeks. In the meantime, the department to file affidavit bringing it stand on record. Yes, now 1004/2023.
The other two writ petitions, the appeal is pending before the commissioner, my lord.
Other two, which are the two writ petitions?
My lord, 58 and 60, my lord. I think 58 and 60, my lord.
1004.
1004 and 1008.
All right, so,
1004, but I have filed an IA.
all right. So according to you, he is not eligible.
He is not eligible.
Why is that?
According to him also, on your lordship, please to see his petition, paragraph 9 of the writ petition itself.
If I am permitted to submit, my lord.
You will. Have some patience.
My
Some
lord.
patience.
Paragraph 9 of the writ petition, my lord. He was only 3 months away from being 30 years at the time of advertisement.
Where is the advertisement? Let him submit. Mr. Saikia, where is the advertisement?
Advertisement also will find at page 32, my lord.
Yes. What is the age qualification?
Is 30 years as on the date of advertisement, my lord.
Which clause?
My lord, clause 2.
So advertisement was issued on 2/9/2022.
Yes, my lord.
What was your age?
My lord, at that time, my lord, I was 3 months short.
Then you were not eligible.
I am not eligible on the date of advertisement, my lord. But the private respondent also, he is also not eligible. Because, my lord, he has 3 children and, my lord, he doesn't have landed property in his name.
No, but unless you are, see, the law is like this. You can challenge the selection of someone else and seek a writ of certiorari.
My lord,
If you are,
my-
listen. You will not get the time because I'm not going to repeat it. I'm going to pass the order. You listen, it will help you in some other case.
my lord.
I'm going to pass the order that I will pass. That I don't need you to hear. But I'm telling you this so that if you know these things, it will help you in some other case. You cannot ask for a writ of certiorari unless a writ of mandamus is maintainable. That is the law. You cannot ask for a writ of mandamus to appoint you as Gav Buddha. That is the reason I'll close this matter. You have 5 minutes to argue. Please.
My lord, I am, my lord, praying with a warrant in this case, because this is a public post. Post of Gav Buddha is a public post. If a person is not qualified to hold the post, he cannot be appointed. And if he is, my lord, appointed, then lordship has the authority to interfere into the matter, my lord. Even if I am not qualified. On the
Where have you mentioned writ of quo warranto? The prayer says certiorari mandamus.
no, my lord, or any other appropriate writ, my lord.
No, that I will not. The quo warranto has to be specific. That's the law. That is the law. Unless that is specific, it cannot be done.
My lord, I'll have to say I'm in the prayer, my lord. But because, my lord, my entire pleadings is, my lord, on the basis of quo warranto, my lord.
But then
Yes,
that writ has not been prayed for.
Well,
Is he
it
paid
is-
for his mandamus or certiorari?
My lord,
Then you will have to withdraw it.
certiorari or any other appropriate read, my lord.
You have to make out a case of quo warranto and then ask for that writ.
Yes, ma'am.
Where is that prayer?
Prayer is, my lord, though it is specifically not mentioned, prayer is there, my lord.
You finish your argument, please.
My lord. My case is that as he is not qualified, page paragraph 18 of my.
Do you
petition,
want to withdraw and file again? No, that you don't want.
Then, my lord, I will have to withdraw and refile.
You make up your mind. Otherwise, I'll dictate the order. If you succeed, you succeed. If you fail, you fail. Matter gets shut out. If you want to withdraw, then it is another matter. Choice is yours. Mr. Saikia, difficult. Law is difficult, not easy. So it is not going to be easy.
That common prayer I copy pasted.
I don't want to
Then, my
hold
lord,
that,
I'll
I
withdraw
don't
and
want to
refile.
hold that tutorial now. But if
Then
I did, I would have shown you how this petition is not maintained.
Tomorrow I'll file again.
All right, heard Mr. Ayat Sekal and counsel appearing for the writ petitioner, that is in WPC 1004 of 2020, who seeks leave of this court to withdraw this writ petition with liberty to file afresh by incorporating all the prayers the petitioner is seeking before this court. The prayer for withdrawal with liberty is not opposed by Mr. B.C. Das.
My lord, I am opposing it with liberty.
No, he
Because
wants
he-
to. He wants to file a writ of quo warranto. How can we shut him out on that?
That's. But he has,
All right.
he has
Although
challenged,
Mr. B.C. Das, Learned Senior Counsel, assisted by Mr. S.H. Rahman, Learned Counsel has opposed the prayer.
liberty part. my
His
lord.
objection is hereby overruled. This writ petition stands disposed of on withdrawal with liberty as prayed for. However, interim order, if any operating in this case, shall stand vacated. Consequently, is there a IA in this?
Yeah.
In view of order dated so and so, IA stands disposed of.
Disposal.
And what about the other writ petition? That is also
Other-
quo warranto?
No, my lord.
What is the other writ petition? Let us see, 100.
The writ petition, my lord, lordship may dispose of, my lord, directing the commissioner, law and division, my lord, to take a call, my lord, on the appeal filed with the petitioner, my lord. She is the in-charge Gambura of the village, my lord. She is the wife of late Gambura, my lord. And the private respondent, my lord, he has criminal case pending against him.
So let the appeal be disposed of.
Lordship, the law instruction from the Lower Assam Division, it says that they have sought for some comments from the Deputy Commissioner. They are doing it. Malad. They will
All right,
consider.
heard Mr. Ayat Sekar, it was WPC number 1008 of 2023. Heard Mr. Ayat Sekar, and counsel for the writ petitioner. Also heard Mr. B. Nath, Learned Senior Government Advocate Assam, appearing on behalf of respondent numbers 1 to 5, and Mr. H. Ali, Learned Counsel appearing for, no, Mr. S. Datta, Learned Standing Counsel Revenue for 1.
1 and 2. 1 and 2.
1 and 2, Mr. D. Nath,
3, 4 and 5.
Learned Senior Government Advocate Assam for respondent numbers 3, 4 and 5. And Mr. H. Ali, Learned Counsel for the respondent number 6. Full stop. In this writ petition, the petitioner has challenged the selection of respondent number 6. Namely, Mohammed Jil Haq, J.I.L. Haq, for appointment in the post of Gav Pradhan of charge number 12 under Bagbor Revenue Circle in the district of Borpeta. Full stop. However, it has also been brought to the notice of this court that the petitioner has in the meantime preferred an appeal under Rule 162 bracket C bracket close of the executive instruction framed under Assam Land and Revenue Regulation, 1886, before the Divisional Commissioner of Lower Assam, that is the respondent number 3, which is pending disposal. Mr. Nath submits an instruction that the Respondent number 3 is actively considering the appeal and the same would be disposed of in a time-bound manner. In view of the above, this writ petition stands disposed of by directing the respondent number 3 to proceed with the appeal pending before him and dispose of the same in an expeditious manner, preferably within 45 days from today. Until such time the appeal is finally disposed of, interim order dated 22/2023 shall hold the field. By interim order dated 22/2023 passed in this writ petition shall hold the field. Writ petition stands closed. Is there a IA in this?
Yes, I is there.
IA number? IA stands disposed. So
There is,
two writ petitions disposal, two IAs disposal.
there is another IM, 716.
What is that for?
716 was filed by the petitioner that the stay order was not complied with by the circle officer. In fact, he was personally directed to appear. He appeared, he tendered his apology and filed an affidavit in opposition.
Then this will also be in view of order passed in writ petition 1008 of 2023, IA number 716 of 2023 also stands disposed. Mr. Saikia, please do some reading on writ of quo warranto. These are very interesting things you will find. Do some reading, you will feel good when you argue before the court. Don't fire shots in the blank. It will be more counterproductive for your client. Do some reading, you are a lawyer, you are a good lawyer, I would believe. Come up with proper case before the court. If you have made a mistake, say that I have made a mistake. You did not want for a writ of quo warranto, that was an afterthought. That is how the case has been projected. This is going to hit a roadblock very soon. On the third question the court will ask, you will not be able to answer. But I won't tell you that because you are going to come back again. You make your own research.
My lord.
Yes, that is how the bar, the profession grows.
Yes, sir.
Yes.
I'm deeply obliged. my lord.
Lordship knows the case. The petitioner was given the penalty of reduction of 5 stages in.
আপনি যাও এই নালাই মাটিলে আহিব যেতিয়া মাটিব তেতিয়া আহিব আপুনি হেৰি কৰক আপুনি যাওক ক'ব আপোনাক খবৰ দিব যেতিয়া মাতিব তেতিয়া আহি লওক হেৰি নাই খৰখেদা নাই লাগিলে নাহিলেও
The penalty of reduction of.
All right, please let us start with your case. What is your case really?
Lordship, after a disciplinary proceeding,
No, please go one by one. Your client was working as what?
as a manager.
Manager
Scale
in?
2,
Huh?
as a manager, grade scale 2 in Grameen Vikas Bank. At the material time, when the disciplinary proceeding was initiated against him, he was at Dibrugarh, Barbarua branch. Lordship. There, the NABARD, National Bank for Agricultural Development, and State Agricultural Department floated some schemes for financing agricultural activities and also piggery, goattery, etc. These things. Because piggery and goattery, these are all allied agricultural activities, Your Lordship. And the controlling office of the bank, through various circulars, instructed the branches to disburse the loans within a specified time limit of almost about 2 months, Your Lordship. Within a period of span of 2 months, some hundreds of loans were to be disbursed. The borrowers were identified by the NABARD and the Agriculture Department, and the list were sent to the controlling office of the bank And the controlling officer of the bank sent these proposals to the branches for sanction of the loans, Your Lordship. And the borrowers were never identified by the branch manager or branch at the branch level. Therefore, whatever was done at the controlling level, and the process of sanctioning loans started, Your Lordship. And in the process, some schemes of organizing loan melas were also directed to be conducted by the controlling officers of the branches at regular intervals in the rural areas, in weekly. So that way, the loan applications were processed. The Gaon Panchayat presidents and secretaries also came to the branches, and through them, the borrowers were identified, and they identified the borrowers, and the proposals were sent to the branches, and the branch manager appraised the things and sanctioned the loan. In sanctioning the loan, Your Lordship, it is alleged in the charge memo that some irregularities were committed by the delinquent officer, Your Lordship. These irregularities were of the sort that some amount were sanctioned, and the margin money was to be deposited in a particular account, and because and that is an irregularity, of course, that is right, of course, Your Lordship. But then the amount of margin money was to be deposited in a separate account, Your Lordship, on the same date. But because of the accidental paucity of time, Your Lordship, the amounts were not deposited in the specified account on the same date, Your Lordship, and those were adjusted on the next date, Your Lordship. If Your Lordship comes to the third memo, Your Lordship.
Yes, that is page number.
That is at page 26, Your Lordship. That is at page 26.
Yes.
I'll trouble Your Lordship with trouble of going to back and forth to the reply filed by the petitioner, Your Lordship. Now, coming to page 26, Your Lordship. Serial number 1, Your Lordship, paragraph 1.
Yes.
Paragraph 1, Roman 1, Your Lordship, Roman small 1. That is what I just mentioned, Your Lordship, that the margin money were deposited in a different account. That has been explained. He admitted, petitioner admitted the irregularity, Your Lordship, and with an explanation that the amount were adjusted on the next day. So, in fact, that is not a serious irregularity or misconduct, Your Lordship. That cannot be construed to be a misconduct, Your Lordship.
Can we just read it? What was there? What is there here? Article of charges, let us see.
Charges in 1 Roman 1, Your Lordship.
Yes.
In sanction of these loans, you have made deviation in respect of loan amount component vis-a-vis the subsidy and margin money component. As per NABARD subsidy scheme, subsidy component are 33.33% and margin money 10% of the total outlay. But you have sanctioned loan of rupees 2 lakhs, each including margin money component of rupees 33,400 instead of actual eligible component of 20,000. Thus, the bank loan component was brought down to rupees 1 lakh in irregular manner, violating norms, which was done to avoid avoid deposit of collateral securities of the borrowers. That has been addressed at page 33, Your Lordship. Paragraph 1, Your Lordship.
Yes.
41 numbers of BMT loans are sanctioned under capital subsidy scheme of NABARD, taking unit cost of rupees 2 lakhs each. Considering the weak economic condition of borrowers, I have reduced the loan amount to rupees 1 lakh instead of rupees 1.13340 each to give them an impetus to implement the schemes. Otherwise, it would cost them a burden of at least 54,000 in the form of collateral and margin. As the project was an initiative of Dulia Kakoti Village Panchayat, that is what I had mentioned earlier, Lordship. These proposals were sponsored by the Gaon Panchayat, NABARD through Gaon Panchayat, and this funding of the government's machinery here also. And would be in a position to get additional supervision from the local authority. I consider it prudent to accommodate borrowers with the concession. Mrs. Kunjalata Sunwal, president of the Panchayat, was very interested to initiate the project. Though NABARD has suggested a cap of 10% margin requirement, I suppose the limit is not a hard and fast rule. NABARD's guidelines are suggestive in nature. So therefore, this charge, Your Lordship, doesn't hold much water, Your Lordship, because there was no irregular access, because these schemes, these loan schemes were floated by the government to help the needy and poor people to uplift the economic condition of the rural population, Your Lordship. That is why the burden of capital subsidy or this margin money deposit, that was reduced so that they are not burdened with the additional amount to be paid by them, because they are poor people of the rural areas, Your Lordship, and their lot has to be improved. That is why these schemes were introduced by at the highest government level, Your Lordship, and through NABARD and all the rural banks, this percolated, Your Lordship. And this is the explanation for charge 1, Your Lordship.
All right, yes.
Then charge 2, Your Lordship, Roman 2. In disbursement of these loans, marginal deposit head was debited on so-and-so with 31/1/12, Your Lordship, that is the date, 31/1/12. Corresponding credit to demand draft account in most unauthorized manner for an amount of rupees 4,10,000. Rupees 10,000 each for 41 loans. That is the margin money, Your Lordship, per borrower, Your Lordship. And that was kept in a draft account, Your Lordship, drafts were issued and kept in provision for being transferred to the specified account, Your Lordship, at a later stage. To facilitate payment of insurance premium to Bajaj Alliance Company Limited. But on this date, so-and-so, no credit was there in marginal deposit account of the branch as against respective borrowers for payment of insurance premium. So therefore, these amounts were kept in abeyance for payment to the insurance company, because insurance is a compulsory component of the loans, Your Lordship. That the bank's interest for repayment of the money is to be insured, and that insurance gives the guarantee that the money will be repaid. That is the idea behind deducting the insurance premium from the borrower, Your Lordship. And that was deposited in the bank, and on a subsequent date, this sent to the remitted to the concerned insurance company, Your Lordship. This also doesn't amount to, Your Lordship, misconduct, Your Lordship. Then number 3, Your Lordship. One assistant manager was there in the branch to conduct pre and post-sanction visit in appraisal of the loan proposals. But it was found that the services of this assistant manager of the branch was not utilized
by you for the purpose of unit verification of appraisal of loan proposals. Instead, you resorted to dispose these loans all alone with manifold irregularities. This is a deliberate attempt on your part to violate the bank's guidelines so far as disposal of loan proposals. This manifold irregularity is a misnomer, Your Lordship. There are no manifold irregularities. Moreover, Your Lordship, I was not able to garner the help from the assistant manager because that person was not efficient in his work, Your Lordship. And to that effect, I wrote a letter to my controlling office that this person has to be replaced and an efficient person has to be provided so that I can get assistance from him in a real terms, Your Lordship. But that was not responded by the controlling officer, Your Lordship, and therefore, without help of the assistant manager, I had to do it on my own, Your Lordship. And there was no mala fide intention because I instructed the manager, controlling office, that this is the position that this person is not in the position to accord any kind of help, Your Lordship. Therefore, he has to be replaced and given another person has to be given so that the proper assistant can be had from him, Your Lordship. So this also doesn't hold water, Your Lordship, because it was incumbent upon the controlling office to provide with a different person who is efficient enough to render his assistance to me, Your Lordship. Now, Your Lordship, Roman 4, Your Lordship. For the aforesaid irregularities, no subsequent disbursement in respect of these loans could be made by the branch, and as such, these schemes could not be implemented. As a result, no recovery from these loans are forthcoming. The bank has thus been exposed to suffer substantial amount of financial loss. This statement that charges allegation that their bank suffers substantial loss doesn't hold water because, Your Lordship, immediately after sanction of these loans, I was transferred from Bargura branch to Sibsagar branch immediately. I was there in the Bargura branch only for 7 months, Your Lordship. And during this period, under pressure created from the controlling office, NABARD and Agriculture Department, because off and on, the officers from the NABARD, officers from the Agriculture Department, everybody comes to the branch and pressurize that these loans should be disbursed because there is a target fixed. A target is set and that has to be fulfilled because the report has to go to the topmost level, Your Lordship, at a ministry level, Your Lordship, because these loans were schematized.
What was the penalty given to your client? What is the penalty to your client?
Higher stages reduction in with cumulative effect, Your Lordship.
And he has already retired.
He has already retired on 30th April, Your Lordship. Moreover, Your Lordship, he is a victim of some lobbying, Your Lordship, because he has retired and his gratuity has been held back, Your Lordship. There is no disciplinary proceeding on the date of his retirement pending. And still then, they have held back the gratuity amount, Your Lordship. This is a pure case of victimization or whatever, fulfilling some other grudges, Your Lordship, because this officer, Your Lordship, he was not the yes man of the controlling officers.
That argument should not come
That's
here.
all right, that's all right.
This is off the record, my lord.
No arguments will be able to prejudice this court. This way, that way.
I am aware.
Don't be bothered about that. I think we are experienced enough to understand what is what. But the point is, yes, we'll go by the record. We'll see what the charge, if it has been established by cogent evidence, no interference.
Yes.
Otherwise, there will be interference.
Then coming to charge number 2, Your Lordship, page 27, Your Lordship.
Yes.
Roman one.
That is 27 or 28.
27. Oh, there.
All right, you
That
carry,
is-
you carry on as per your pagination.
Oh, actually, that has come a statement of allegations. Your Lordship.
No problem, you read it.
You have sanctioned, as per guidelines, the first phase of disbursement of KCC loans are required to be utilized for works related to preparation of land and for purchase of seeds. But it is found that a sum of rupees 3,000 each was debited to all the 117 KCC loans account in so-and-so as first phase disbursement of loans by using KCC withdrawal slips only signed by the borrowers, which were utilized their transfer debit voucher with corresponding credit to demand draft account. So the borrowers were not been able to utilize the amount of the works related to cultivation of potatoes since the amount of rupees 3,000 each were paid to Bajaj Alliance Insurance Company as Tatkal Bima premium. Thus, we have violated the bank's guidelines. Bank has not issued any guidelines. Rather, some Tatkal schemes were floated by the insurance companies, and those were circulated to the branches by the controlling office. That.
So where is the finding of the inquiry officer? Inquiry report is that page.
Inquiry report, your lordship will find at page 63, my lord. And the finding at page 71.
That is that page 71, analysis of charge by EO. Down below your lordship, charge 1:1. It is evident as per ME 7. As per ME 7 and collaboration of MW1 in response to question number 1, 2, 3, 4 as recorded in the proceeding book, read with ME 5, 6, 7, that are all 41 numbers of empty agriculture and right sanction loan were sanctioned by CSO with limit of bank loan of rupees 1 lakh. NABARD bank ended subsidy 66,600 and the margin money of rupees 33,000 per prescribed loan amount is out of the scheme. The argument of CSO is not based on fact because the enhancement of the loan portion 20,000 to 33,000. In all, 41 number of loans were done only to sanction the loan under relaxed norms of security for agriculture up to 1 lakh. Thus, the charge number 1 is proved. That, as I have explained in page 33, your lordship, that was done to giving boost to the economic condition of the people, your lordship, and to promote the economic lot of the rural population, your lordship. That is done. Then.
So the inquiry officer has not dealt with your response.
No, your lordship. And some other management witnesses also said that there was no irregularity committed. Some witnesses say that
He
there
did
is
not
no,
reduce any evidence, my lord. He just stated in the petition, but then your lordship will find in the disciplinary proceeding, he did not reduce any evidence. That will be have to
That
be
is correct, but if the delinquent official takes a stand in his written statement,
My lord.
is that not required to be considered before arriving at a conclusion?
That is, of course, but then he
ought to have given his evidence on the basis of his statement given.
No, no, Mr. Datta, what I am asking is, this is a pure and simple technical question of law.
Yes, yes, yes. He could have.
Forget. You issue a memorandum of charge and ask him to respond. He gives his version. He may be able to prove his version or not. But whether his version has been considered by the inquiry officer, is it not a relevant consideration?
You know, in all the charges, your lordship will find in other charges is very clearly given. Possibly here, he did not distinctly say all that. But in other charges, your lordship will.
The charges I have already read, your lordship, there is no misconduct, alleged misconduct proved. Your lordship. And your lordship, if your lordship comes to page 79, that is the penal order, your lordship. Even prior to giving me the opportunity to respond to the penalty imposed, the disciplinary authority says that I have concurred with the report of the inquiry officer. How, your lordship, is it not necessary that his response should be considered before concurring with the report of the inquiry officer? Is it not a mandate of law, your lordship? At page 79, your lordship.
Yes, page 79.
79, your lordship. Second paragraph, your lordship. Second paragraph, second sentence, your lordship. I'm reading from the beginning, your lordship, second paragraph. I have carefully perused the records of the inquiry, day-to-day proceedings, evidences adduced, briefs of both sides, findings of the inquiry officer, and your submission thereon. I concur with the findings of the inquiry officer and am satisfied with the evidences recorded at the inquiry and have come to the conclusion that all the charges leveled against you have been proved and established beyond doubt. And ultimately the reduction of basic pay by 5 stages with cumulative effect.
This is a major penalty.
Major penalty, your lordship. Now, coming to Roman 2, your lordship. One assistant manager that I have already mentioned, your lordship. I have written a letter to the controlling office that this person has to be replaced and an efficient person has to be provided so that I can derive the benefit of his assistant, your lordship. That was not done, your lordship. No response, nothing. Therefore, I had to do it on my own. And pressure was so high that I had to work. That is, of course, that is not very material concern here, your lordship, but that is the fact of the case that I had to work till 10 o'clock, 11 o'clock, your lordship, at a branch.
No, Mr. Datta, this is one aspect the court will seek your assistance for a satisfaction. The inquiry officer appeared to have gone on a very mechanical manner. This is his argument, this is his argument, this is my finding. All three are in different compartments. He said this, he said that, I said this. Well, then where is the application of mind here? See, all his thing, what he's saying, PO's argument is this, the defense argument is this, but the PO's argument and defense argument has no mention in his analysis and reasoning, where he says that the charge is proved. What kind of an inquiry proceeding is this?
Hello, your lordship will find, say charge number 2, 1 to Roman 2.
Yes.
Now 41 loans marginal deposit account was debited on 31/1/2012. And on this date, there is no amount in credit of the marginal deposit account. Now what he did, he has debited from some other account. This is, my lord, totally temporary misappropriation of the amount, because if the money is not there, how you are debiting? Now, who has authorized him? He ought to have taken consent, and no officer also, higher officer also.
So then where is the finding? Where is the
Lord,
finding? What you are saying, where is it reflected in the inquiry report?
my lord, if I'm reading in the middle part, it is evident that no amount of margin money was credited in marginal deposit account against these 41 borrowers as per ME 7 on or before 31/1/2012, which was to be obtained on or before disbursement, that is 31/1/2012. The first phase of loan was released rupees 36,000 each on 1/2/2002. Now he has disbursed the amount on 31/1/2012. On that date, there was no money on account. Now he has disbursed, he is allowed to disburse that amount, although there was no money in the account.
No, Mr. Datta, temporary misappropriation is a grave charge. Where is the charge? Where is the finding? Without that, you can't argue that there was a temporary
So,
misappropriation.
my lord, this
There is no
itself
charge, Your Lord.
indicates.
Take your seat, please.
My lord,
Yes.
this itself indicates when he is debiting an account, my lord, in my the affidavit also I have stated that if your lordship look at my affidavit, page 9, paragraph 12, my lord, 24. My lord, I'll just read it. In regard to the statement made in paragraph 21, 22, your deponent begs to state that it was proved in the inquiry that the petitioner was irregular in his action in the area of unauthorized transaction in the marginal deposit account. Non-utilization of service of the assistant manager posted there in the branch for the purpose of pre-sanction or post-disbursement verification of the units, etc. In case of marginal deposit account, the petitioner debited the same for an amount of rupees 4,10,000 only to pay insurance premium against 41 MTL borrowers, where no money was there in the account in the name of these borrowers. In other words, the petitioner debited the amount from others' account to pay insurance premium in most unauthorized manner. Now, your lordship has seen, he has not taken the assistance of the assistant manager credit. Now, the argument is that he was not an efficient person. Now, it was your duty to get the pre-sanction, post-sanction from him. If he commits any mistake, that is his part, you are not his guardian. That he will make a mistake, therefore I will not give him to do the work. So that stand, my lord, cannot be allowed. Now, once you cannot pay the amount unless there is money in the account, my lord, can it be done that way? Otherwise, all the managers will do that at the, my lord, the cost of the bank. And the, my lord, the role of the manager, as your lordship understands, it will have to be sacrosanct, my lord. The people's trust is on them. Now, if they does all these things in a smaller way, they will make a big ocean. And exactly these things, otherwise he will not, why he could not take the assistance of this assistant manager credit? Because he was the main person to give a pre-verification report, post-verification report. He did not allow him to do all that. And not only this, your lordship will find the sanctioning authority is granted sanction on a certain date, but before that sanction, prior to that, he has given the loan.
Let him finish, then we'll hear your argument, because you finish.
To that I will respond that.
No, you finish your argument, then we'll hear him, and then you reply, and then we'll close the matter.
So therefore, this is also not proper that I was not given the opportunity of responding to the charges level penalty imposed against me. And prior to my filing the response, your lordship, I was imposed a penalty after concurring with the report of the inquiry officer. Moreover, your lordship, there is no charge of any bribery or corruption. Nowhere there is any such charge, your lordship. And about misappropriation of money or defalcation of money is not there, your lordship. No charge is there, your lordship. And the 4,10,000 mentioned of is realized for payment of insurance premium, as I have already said, your lordship. That insurance premium were deducted from the sanctioned amount sanctioned to the borrower, your lordship, and that was deposited in a draft account, your lordship, and that was on this subsequent date, immediately. That was transferred to the requisite specific account, your lordship. That is done, your lordship. So regarding these charges, my explanation is this, your lordship. Now, I assail this on the first ground that the penalty that the disciplinary authority at the material time was the general manager.
No, but that we have seen that was amended in 2015.
That was my contention is that, your lordship, that when the process of disciplinary proceeding was initiated, should it not have been allowed to be governed by the rule existing at the time when the disciplinary proceeding was initiated till the culmination of the process? In this respect, the amended rules are not applicable, your lordship. I have a cited from your lordship, 1997 10 SCC 419, your lordship. This says amended rules are not applicable, and that has to be the old rules must govern. The original rules would govern and not the amended ones, your lordship. That I have highlighted the relevant portions, your lordship. On the first page, item F, your lordship, held. The posts which held vacant prior to the amendment of the rules.
This is in the context of promotion and recruitment.
Whatever, your
That does
lordship.
not apply here.
But that is the rule set by the apex.
That
order.
says when the vacancy arose.
Whatever rule is existent at the material time should govern the whole process till the culmination of it. That is the basic concept, your lordship.
So the departmental proceeding was initiated by serving the memorandum dated 1/3/2014.
Lordship.
What was the rule on that day? Where is the rule? Is it a part of the record?
The regulation, other day I have furnished one regulation.
That was the amended one in 2013, your lordship. And though
Just 1
the
minute, yes.
disciplinary authority here is, your lordship, the general manager, the charge memo was issued by the chairman as the disciplinary authority, your lordship. And subsequently,
Where does one find it?
that is at page 28, your lordship. Page 28, that is the chairman of the disciplinary authority signed the charge memo, your lordship. And on that particular date.
Is this what you are referring to, Mr. Datta?
Yes. Competent authority, your lordship will find at, my lord, section 2G, my lord. Page 2, my lord.
Page 2. Z, your lordship.
So who is an officer and who is an employee?
In earlier regulation, my lord, chairman.
Chairman is an employee.
No, chairman.
Competent
is,
authority.
The appointing authority.
So the petitioner was an officer or an employee?
Officer, scaled officer.
He was an officer.
My lord.
So as per the earlier rule, competent authority means chairman in respect of an officer.
Yes,
So it should be chairman, not general manager.
earlier rule.
earlier regulation.
Then
Now, my
amendments. have
lord,
been-
even if it is so, my lord, even if it's relying on the earlier regulation, the law is very clear. My lord, I'll just read 2 lines from a appeals court decision. It is now well settled legal position that an authority lower than the appointing authority cannot take any decision in the matter of disciplinary action. But there is no prohibition in law that the higher authority should not take decision or impose the penalty as the primary authority in the matter of disciplinary action. So therefore, my lord, it's not going to affect his case because
That is correct.
in such a case, my lord, so far, just a minute. So far, my lord, he has to file an appeal. That provision remains before he can file an appeal before the board. So he's not going to be prejudiced by it.
So has he filed an appeal?
I'm not sure, my lord, he did not.
Have you
annex.
filed an appeal?
No.
Why haven't you filed? Appeal provision is there.
Provision is there, your lordship will find at regulation
It was not
50.
filed, Your Lordship. It was not filed.
Why?
That I am not aware of, Your Lordship. But then
Where is the provision for filing?
50, my
appeals?
lord, 50. Is clearly indicated. An appeal, as a lordship document. An appeal shall lie before the board where the chairman is the competent authority. So he is not losing the forum. my lord.
No, but that's a relevant question, Mr. Sharma. When there is a appellate provision provided. in
Madam
the
Your
rules.
Lordship, even the penal order was passed by the general manager again, Your Lordship. He was the disciplinary officer, that is all right. But then when a major penalty is to be imposed, approval from the competent authority has to be obtained.
That is why the appeal. That is
Because
the reason why the appeal.
in passing the penal order, Your Lordship, there was no approval in writing receipts from the competent authority, Your Lordship. And
My lord, I
Rules
fail to
were-
understand the meaning of this because after the amendment, obviously, my lord, chairman cannot pass this order. General manager will have to pass order. Because it was passed on 39/2015 and the amendment was done on just before that, my lord, 15/2/2014. So therefore, in any event, my lord, the chairman is no longer there as an appointing authority. Any disciplinary action will have to be taken by the general manager.
So that has been done. It is the general manager. who
Yes,
has passed the
it's rightly done.
So then an appeal lies.
no, but then in passing the penal order, Your Lordship, in passing a major penalty, Your Lordship, approval from the competent authority is mandatory, Your Lordship. And on the present date, Your Lordship, the competent authority is the chairman, Your Lordship.
You will have to file an appeal. But as far as his gratuity is concerned, why the gratuity has been held back?
My lord, this is the argument he has advanced. I do not know what is the position.
This has nothing to do with gratuity.
No, my lord, we are not concerned about this. If he has not been paid,
But
my learned friend can file a case.
I am just casually mentioning, Your Lordship, because he has retired.
Because I don't have any instruction whether he has got it or not.
Is it possible to telephonically get an instruction?
That
Can you just get it? Because gratuity, that we will issue a direction. That cannot be stopped.
gratuity, my lord, your lordship may see
Yes, it retired on. in
the regulation. I'll just take to your lordship, regulation 72. (72)(1), your lordship can see. An officer or employee shall be eligible for payment of gratuity either as per the provisions of the Payment of Gratuity Act 1972 or as per sub-regulation 2, whichever is higher. Number 2, every officer or employee shall be eligible for gratuity on retirement, death, disablement rendering him unfit for further service as certified by a medical officer approved by the bank, or resignation after completing 10 years of continuous service, or E is important, termination of service in any other way except by your punishment after completion of 10 years of service.
Now, if the service is termination of a service after any disciplinary proceeding is held, in that case, he will not get gratuity. So in here, Lord, that position is not there. So therefore, he is eligible to get the gratuity. Now, whether he has not been paid or not, I don't have that
No,
instruction.
but he says, can you find out from your client?
That has not been paid here also. That is
I
for
can
sure.
get that instruction. There is no problem.
That is for sure.
No, then if you can get it, then we'll dispose it right now.
The delinquent officer is here, Sir, Your Lordship. He has come.
No, whatever, then you find out, you ask him,
It has not been paid here also. Yes.
gratuity has to be paid within 15 days.
No, that is, it is open, my lord, but in this case, possibly we are not concerned with that. In this particular case,
Yeah, he says he's not been paid his gratuity.
well, that's a different cause of action because he has retired. The retirement benefit he will get, obviously. Because if there is no impediment in the regulation, obviously my lord is eligible to get that. But then
So anyway, if he's a retired employee, we'll provide for that.
that is obviously, my lord.
And
If
insofar
there-
as the order is concerned, that will grant him liberty to file an appeal.
Yeah,
Because
that
there
is
it
there.
is only the
You know,
monetary.
that position, can your lordship give me 2 minutes time? Let me have an interaction with my client.
Yes, please.
Mr.
Mr. Sharma, these are matters, there are number of judgments of Supreme Court. Particularly when it deals with the matter of observance of procedural requirement, irregularities in function of manager's job as a bank manager. Mandatorily appeal has to be filed. Because these are very technical matters. The courts will be, listen to this, listen, it will be. I can always pass the order without disclosing, but I am disclosing because what happens is, once the appellate authority applies his mind, the court is in a position to know which way the whole thing has gone. So obviously, you will have to prefer an appeal. All we'll do is ask them to decide the appeal in a time-bound manner. And if you are aggrieved, you can come back. Number two, since this penalty imposed on you will be subject to outcome of the appeal and further proceedings. And since there is no bar on the rules for settling your pensionary retirement benefits, including payment of gratuity, we'll ask them to do it expeditiously. Within 2 months from today, they have to settle it. This is the order we'll pass. What order else can be passed? There is no other order that can be passed today. Once the appellate authority applies its mind, then only we call. Once the appellate authority applies their mind.
Give it to your lordship to wisdom.
No, there is nothing to leave. This is the way it is. This is the way it is. Without the views of appellate authority, how can an order of penalty be directly interfered with? You raise all these grounds.
Lordship.
What have you got to say in that?
I leave it to your lordship. Whatever is deemed proper, your lordship will pass. That I have the complete faith on you, the wisdom of your lordship, your lordship.
We'll ask them to pass a reasoned order in a time-bound manner.
Because
all
he has
the
already
points.
retired, time limit may be shortened, your lordship.
2 months, within 2 months. Within 2 months from date of receipt of appeal. They will have to decide it. They will have to decide it in a particular manner by giving proper reasons. Otherwise, the appeal will be forfeited. The entire thing will go. But we have to follow the requirement of law. That cannot be changed. And there will be a direction that they settle your retirement dues along with gratuity within 2 months. That's all. That's the only order.
That will be all right.
If you are aggrieved, who knows, you may get the relief. Or if they pass an order, your client may actually get a good ground to challenge it. But unless that is there, what can the writ court do? We cannot substitute our views. We cannot say that he was guilty or not guilty. We can only say that from materials, these are arbitrary. Now the one-sided version is there, other side is not there. Let us see what the chairman and the board holds. That's the way forward. This matter has been pending so long, otherwise.
Yes, lordship, that's right.
We call the. What are the pensionary dues?
gratuity, pension, then contributor provident fund, leave encashment.
Yeah, very nice. Lady was nice, you know. Oh, I had asked you to call him. ঠিক আছে, I see, yes. এগুলোই মাটি ঘটিছিল।
My instruction is, it is under process.
All right, then he'll prefer a statutory appeal. Is the competent, the appellate authority to decide within 60 days
Yes.
by a reasoned order,
Right.
dealing with all the points raised by the petitioner.
Very good.
And in the meantime, you settle his pension, provident fund,
Yes, yes,
gratuity, whatever.
they are bound to do that.
And if he is aggrieved even thereafter, let them come.
Yes, definitely.
They can review the penalty.
Yes. It is open to them.
It is open to them. So we'll make it clear that it will be open for them to review the penalty, order of penalty also, and impose a lighter punishment to the petitioner if so advised.
All right.
That observation would. Definitely, all right.
Heard Mr. A. Sharma,
R.
learned
Sharma.
counsel. R. Sharma, yes. Learned counsel appearing for the. Mr. Your full name is Mr.
Roman Sharma,
Mr. R-U-M-A-N.
R-O-M-A-N.
R-O.
I don't belong to Rome.
You're not from
I'm
Rome. This is the Indian Roman.
Indian Roman.
All right. Or the Assamese Roman. Okay. Roman Sharma, learned counsel appearing for the writ petitioner. I have also heard Mr. S. Datta, learned senior counsel, assisted by Miss
S.
Musahari, learned counsel appearing for the respondent numbers,
All the respondents.
appearing for all the respondents. First up. The writ petitioner hearing was serving as an officer under the Assam Gramin Vikas Bank.
He was at that time branch manager, Barbara branch Dibrugarh, your lordship.
That is the respondent number 1. First up. While he was serving as the branch manager of
Barbara branch Dibrugarh.
Borborua branch in the district of Dibrugarh, a memorandum of charge was served. A memorandum of charge dated 01/03/2014 was served upon the writ petitioner containing the article of charges. The petitioner was asked to submit his response. First up, after the petitioner had submitted his written statement, the inquiry proceeding. After the submitted his written statement, the inquiry was held against the petitioner, whereafter the inquiry officer had submitted a report dated inquiry report dated. What is the date of the inquiry report?
Inquiry report of which?
Is it 25/2/2015?
Yes.
25/2/15.
25/2/2015, holding that all the charges brought against the petitioner were proved. Full stop. On receipt of the inquiry report dated 25/2/2015, the disciplinary authority, that is the respondent number
Yes, 79 euros.
pre-hearing had issued the order dated 30/9/2015, informing the petitioner that he concurs with the findings of the inquiry officer and accordingly impose the major penalty of within courts reduction of basic pay by 5 numerical 5 also bracketed out of 5 stages with cumulative effect. Page 79 of PowerPoint, huh? Page 79. Aggrieved by the order of penalty dated 30/3/2015, the petitioner has approached this court by filing the instant writ petition. During the pendency of this writ petition, the petitioner had retired from service on attaining the age of superannuation with effect from 30/4/2023. By referring to the inquiry report, the written statement of defense submitted by the petitioner, as well as the findings in the inquiry report, Mr. Sharma has argued that firstly, there is no allegation of corruption or misappropriation of any money by the petitioner, leading to loss sustained by the bank. According to Mr. Sharma, the allegations brought against the petitioner are all in the realm of discharge of duty by the manager at his discretion, and some steps had to be taken by the petitioner in view of the pressure mounted upon him to implement the schemes and also to deliver in a time-bound manner. Mr. Sharma has further argued that the petitioner had furnished sufficient explanation with regard to each of the charge brought against him by stating the reasons why certain recourse had to be adopted by him while discharging his duties as the branch manager of Borborua branch. However, submits Mr. Sharma, instead of appreciating the stand of the petitioner as evident from his written statement, the inquiry officer had taken a one-sided view in the matter. Not only that, even the respondent number 3 has concurred with the findings of the inquiry officer even before furnishing a copy of the inquiry report to the petitioner, thereby indicating a predetermined mindset on the part of the disciplinary authority in this case. The learned counsel for the petitioner has further argued that since the petitioner has taken a categorical stand that he has not indulged in any irregularity amounting to misconduct, it was incumbent upon the disciplinary authority to give the petitioner an opportunity of being heard before accepting the inquiry report. The same not having been done, Mr. Sharma submits that the entire process stood vitiated and hence was liable to be set aside by this court. It is also the submission of Mr. Sharma that the penalty imposed upon the petitioner is shockingly disproportionate, and therefore, even if the inquiry report is ultimately sustained, even then, the penalty being of grave nature deserves reconsideration by this court, since such a major penalty would not be sustainable on the face of the allegations brought against the petitioner. To conclude his submission, Mr. Sharma has also argued that although his client has gone on retirement on 30th of April 2023, he is yet to receive the pensionary benefits, including the gratuity, and there is a reasonable apprehension in the mind of the petitioner that taking advantage of the order of penalty, his retirement benefits might be withheld, stroke delayed by the bank so as to cause further injury to the petitioner. Full stop. Next paragraph. Responding to the arguments advanced by the petitioner's counsel, Mr. Datta, learned senior counsel appearing for the respondents, submits that the enquiry officer has dealt with the evidence adduced by the bank stroke PO before arriving at a conclusion with regard to the validity of the charges brought against the petitioner. Since the writ petitioner, being the delinquent officer, had never adduced any evidence in his defense, hence it cannot now be said that the findings of the enquiry officer were perverse due to non-consideration of the version put forward by the petitioner. First up, by inviting the attention of this court to the provision of Rule 50 of the Assam Gramin Vikas Bank bracket officers and employees bracket close service regulations, 2010 bracket as amended, Mr. Datta submits that an appeal would lie before the appellate authority.
Lord, that may come from your lordships, my lord. My main submission would be the officer, he acted beyond his authority, which is itself is a misconduct.
Right. Mr. Datta further submits that the charged officer, that is the writ petitioner, had acted beyond his authority and competence and therefore has committed misconduct.
As it has violated regulation 20 of the Assam Gramin Vikas Bank regulation.
Since his actions were in violation of the regulations of Assam Gramin Vikas Bank. First up, insofar as the apprehension expressed by the petitioner's counsel with regard to withholding of pension, provident fund, gratuity, etc., Mr. Datta submits on instruction obtained from the bank that the payment of pension, provident fund and gratuity amount due to the petitioner is under process and the same would be released to him without any undue delay. Full stop. After hearing the submissions made by learned counsel for both sides, this court finds that the order of penalty dated so and so imposing penalty upon the petitioner is an appealable order under Rule 50 of the Assam Gramin Vikas Bank bracket close officers and employees bracket close service, regulation 2010 bracket as amended. Full stop. Since the grounds urged in the writ petition are almost entirely pertaining to the rules, regulations and procedure, procedure and practices to be followed by an officer of the bank in discharge of his regular duty. This court is of the opinion that before the petitioner is permitted to agitate his grievance in a writ proceeding, he should be asked to prefer an appeal before the statutory authority. In view of the above, I dispose of this writ petition by granting 2 weeks' time to the writ petitioner to prefer an appeal against the order of penalty before the appellate authority, which in this case would be the chairman of the bank, chairman of the board of directors.
Before the board of directors.
No, before the board of directors to be headed by the chairman. If such appeal is preferred by the petitioner within 2 weeks from today, by enclosing a certified copy of this order, the appeal be heard on merits and be disposed of by a reasoned order dealing with each and every point raised by the petitioner in the appeal, including the question of jurisdiction of the disciplinary authority to initiate the departmental proceeding against the petitioner as per the provisions of the existing rules at the relevant point of time. Full stop. Over and above the same, the respondents are also directed to release the pension, provident fund, and
Leave
gratuity
encashment.
amount of the
Leave
petitioner.
encashment. No, whatever it is.
Pension and all other retirement benefits to the petitioner, which he may be entitled to under the law within a period of 60 days from the date of receipt of a certified copy of this order. Full stop. If the petitioner continues to remain aggrieved even thereafter, it will be open for him to approach this court by filing appropriate writ petition. With the above observation, the present writ petition stands disposed of. You file an appeal, but file a proper appeal taking the grounds, which has not been taken here.
That will be done.
Yes. At a line of submission of Logamo, the learned counsel for the petitioner has also argued that at the relevant point of time, it was the chairman of the board of directors
Who was the competent authority?
who was the competent authority to initiate disciplinary proceeding against the petitioner. First of notwithstanding the same, the respondent number 3 had served, the respondent number 3 had imposed
The penal order.
the order of penalty on the petitioner, which is wholly without jurisdiction. For that part.
Obligers.
Yes. What is the other petition? Is it?
Two repetition, earlier repetition has been filed challenging the provisional condition list. Thereafter, Lordship, we have challenged the final condition list as well as the speaking order. So earlier, one repetition became infractuous in view of the Lordship final condition is been published. Next repetition, Lordship. Next repetition has been filed. The last occasion, Lordship, we have argued the case. We have not challenged the regulation order by which he was been regularized as early as that. That I have filed by filing separate petition. As an abandoned question.
You have inspected the record?
Yes. Lordship.
Start. Arguing.
Mainly, we have challenged the tradition list of main ground of challenge, Lordship, we have been appointed the LDA stand as per recruitment process initiated by the authority as per recruitment rules. He has been appointed from the works as employee by an advertisement
with the division from Waxas, Khalasi and SA. That advertisement lordship will find that is a notice, that is not an advertisement, that is a notice dated 24/9/1993. Page 37 is a type copy.
So you are arguing from which writ petition?
This petition 6236.
Yes.
On the basis of a notice, lordship will find page 37 type copy. Application from Willing, Waxas, SA, Tracer, Khalasi and third division who got requisite additional qualification that HLC having knowledge in typewriting are invited to fill up the post of LDA in the division. Applications are approved proportional. This is the notice, lordship. This notice has been specifically given to the private respondent. Lordship will find next page, that copy to Sukhendra Narenthor. That was given to the private, that person only. And it is also came to knowledge of the petitioner, lordship. There are 3 divisions in Silchar, water resource divisions. Only this notice has been given to the particular division, that Silchar PC division, FC division, flood control division. Only notice was given for equipment of post of LDS to the Silchar FC division. And it was given only to 4 persons has applied according to them. And after that, he has been appointed as an LDS. And that after the appointment has been regularized by the authority. After getting the affidavit, we have came to know by the respondent that his service has been regularized. Now he has been promoted to the UD. After that, lordship, we have came to know that the lordship government has issued a notification whereby direction was issued to revert back the all Waxas Khalasi who has been recruited to the promoted or recruited to the post of LDS or the UD should be reverted back to the original post. Accordingly, some person was reverted back. Lordship already pointed out. That is why we came to know everything that the order has been passed by the chief engineer, that this order has been passed on 8/9/2022. This order has been issued by the authority chief engineer to revert back all the person who has been promoted or recruited to the LDS or UD. After that, some person has been reverted back. After knowing all this fact, we have filed objection regarding publication of the provisional gradation list, where he has been shown above me. He's above me, he's 1, I am 2nd. Lordship, thereafter, lordship, they have passed a speaking order whereby he have stated that his recruitment has been regularized and he has been, lordship will find at page 64. Page 64 is the order. Relevant position at serial number 4. On the hearing, it is stated that during hearing process conducted on 7/9/2022, as mentioned above, respondent number 4 reported with documentary evidence that he was initially appointed as Waxas Khalasi under office of the executive engineer Silchar Water Resource Division Silchar, order number Iman, communicated number Iman, and subsequently service was extended from time to time. Later on, pursuant to notice issued by executive engineer Division Waxas memo number Iman, inviting application from Willing Waxas Workers Division for filling up the existing vacant post of lower division assistant of respondent number 4 had applied for the same through proportional was selected. Accordingly, executive engineer concerned issued appointment order to him to lower division assistant, renamed junior assistant on 7/3/94 as stated above. He has also submitted that his service was provisionally confirmed on 1/6/2001, along with the other time when he was rendering service as a senior most lower division assistant on Iman, issued by executive engineer Silchar division. Thereafter, he was been promoted to the post of senior assistant during 2008 as stated above and rendering his service in the same cadre. Submission of the respondent has been examined and found to be in order. And accordingly, it is observed the respondent for Sukhendra Johar post of senior assistant, which was far ahead of the appointment of the petitioner in feeder cadre as junior assistant. Again, it is observed the executive engineer Silchar Water Resource Silchar published gradation list of junior assistant on Iman, wherein name of the petitioner is included along with the other on the strength of which petitioner was promoted to the post of senior assistant without any objection. During that time, also respondent number 4 Sukhendra Chaudhary was rendering his service as senior assistant. Carefully, Iman, Guwahati High Court, accordingly, lordship, after carefully gone through the finding of the determination of seniority among the senior assistant in the office of the executive engineer Silchar Water Silchar, more particularly petitioner Shamsundar Saha and respondent number 4 Sukhendra Narenthor Chaudhary as reflected in provisional petition list published at the end of executive engineer Iman. After due consideration all the above, it is found that position of the petitioner as well as response number 4 in that case reflected the provisional gradation list of senior extent under Office of the Executive Engineer Silchar, Waters Division Silchar, published as above is found to be in order. So we have challenged this ground that his seniority has been confirmed by the authority, though there is an order, Lordship will find page 76, whereby the Government of Assam Water Resources Division has informed that inquiry report submitted by the Civil Engineer Water Resources Department on the illegal promotion awarded brought to regular cadre person holding the personal post under Water Resources Division, height letter number Iman. And finally, it is held. From the above, it is clear that the service of workers, master role workers, Water Resources Department, who was engaged prior to 1493 and continue in service were regularized by creating ex-cadre posts when personnel to the incumbent concerned holding the post and automatically abolish or relinquish of the post on whatsoever ground, height letter number Iman. So such temporary creation of post cannot automatically aid the cadre of strength of department and claim of promotion from a person holding the ex-cadre post. It is not legally tenable as such promotion of or bring them to the regular cadre without any prior approval. Order is illegal and are liable to be reverted back. Accordingly, most of the person has been reverted back except him. This order has been issued 2017. We came to know all these orders, and that is why we have challenged his gradation list that he is a works employee and he had come to the LDA cadre on the basis of a notice. Because recruitment rule says, Assam Ministerial Administration Service rule, that advertisement should be issued to the general public who are eligible. The recruitment process should continue. Thereafter, appointment should be made. I have been appointed as per recruitment service rule, Assam Ministerial Service rule. And there is no procedure for a recruitment from Khalasi workers employee to the post of LDA cadre. There is no such recruitment rules. So he has been appointed deho to the recruitment rules, and his appointment is made deho to the rules. So he cannot claim seniority above me. And Lordship, Momota Hoja's case, Supreme Court has categorically stated, Momota Mohanty's case, Supreme Court stated. Lordship, I have given the compilation of the judgment of the Supreme Court, which Supreme Court has already recorded. A person who is holding a recruitment process is illegal. His subsequent promotion cannot stand. Subsequent promotion cannot regularize his service cadre. Though in this petition, we have challenged his initial selection, but we are not claiming that he should be dismissed from service or his appointment should be set aside. Page 35, Lordship. Citation, Lordship, 2011 3 SCC 436. State of Odisha versus Momota Mohanty, Lordship.
Yes.
Page 35, paper 35, Lordship. At one time, the court has been of the view that calling the names of the employment actions would curb to certain extent to manage the nepotism and corruption in public employment. But later on, it came to the conclusion some appropriate method consistent with the requirement of Article 16 should be followed. In other words, there must be a notice published in the appropriate manner which calling the application and all those who apply in response thereto should be considered fairly. In this particular case, admittedly, notice has been issued, and that notice, according to them, published in the notice board. In educate, that also come to light, Lordship, on the affidavit filed by the private respondent. And government, Lordship, we have filed under RTA Act. No information has been provided to us. Para 36, therefore, it is settled legal principle that no person can be appointed even on a temporary or ad hoc basis without inviting application from all eligible candidates. If any appointment is made, merely inviting names from the employment exchange or putting a notice on the notice board, etc., this will not meet the requirement of Article 14 and 16 of the Constitution. Such a course violates mandate of Article 14 and 16 of the Constitution of India, as it deprives the candidates who are eligible for the post from the being considered. A person employed in violation of this provision is not entitled to any relief, including salary. For a valid and legal appointment, mandatory compliance of the said constitutional requirement is to be fulfilled. Equality clause enriched in Article 16 requires that every such appointment to be made by an open advertisement as to enable all eligible persons to compete on merit. Para 37, it is also settled legal proposition that if an order is bad in its inception, it does not get sanctified at later stage. A subsequent action and development cannot validate an action which was not lawful at its inception. So my submission will be Lordship, subsequent regulation cannot validate his initial appointment. For these reasons, that illegality strikes at the root of the order, it would be beyond the competence of the authority to violate such an order. It would be validate such order. It would be an ironic to permit a person to rely upon a law in violation of which he has obtained the benefits. If an order at the initial stage is bad in law, then further proceeding consequent thereto will be non-est and have no necessary be set, not to be and have to be necessarily set aside. A right in law exists only when he has the lawful origin. So my submission will be, Lordship, though I have challenged the petition challenging his regulation order, his initial exception is illegal, so subsequent regulation order cannot validate his appointment. In para 56, it is settled legal provision that Article 14 is not meant to perpetuate illegality, and it does not envisage negative equality. Thus, even in some other similar situated person have been granted some benefit or inadvertently by mistake, such order does not confer any legal right to the petitioner. So in this particular case, Lordship, thereafter, Lordship, Supreme Court has categorically stated subsequent regulation order is non-est in the eye of law if initial appointment is illegal. Because recruitment rules specifically stated that notice should be invited. Rule 6, Lordship, June 6A, by direct recruitment.
So you say that Mr. Chakraborty's client's initial appointment is illegal.
Deho to the rules.
All right. Which is the rule which would have been applicable?
Assam Ministerial District Establishment Service Rule, Rule 6, 6A.
This matter will take some time.
Lordship. So Rule 6 has not been followed.
Huh? Mr. Chaudhary, you have a matter. You have a matter.
Yes.
This may take some time. What do you want to do?
Possible.
If you want to wait, then it's fine.
I think my learned friend is to give a
We choose a date in June. Beyond that, before that, it will not be. Please tell your junior.
8th of June.
Whatever date you give. Yes.
So my submission will be, Lordship, he has been appointed not on advertisement, on a notice issued by the executive engineer within a division.
Mr. Goswami, you will come to the submission later on. First, you point out what are the basis of your stand. So this is appointment to the post of LDA, right? So LDA is a state level cadre or a district level cadre?
District level cadre.
So in this case, the cadre of LDA relates to which offices?
Water Resource Division, Silchar.
Water Resource Division, Silchar. All right. How many divisions are there in Silchar?
3 divisions.
At that point of time?
Yes, Lordship.
Correct. Now, what is the procedure for recruitment as per this rule?
Assam Ministerial District Establishment Service Rule, Rule 6.
Just a minute.
By direct recruitment on the basis of competitive examination constituting of objective type written test, computer test as laid down in Schedule 1 of this rule.
We are reading from this book.
Lordship.
Which page?
Page, Lordship, 197.
(197).
Lordship.
Yes.
Junior assistant, Lordship. Now it is originally it was LD assistant, now junior assistant. On the basis of a competitive examination consisting of objective type of written test, computer procedure as laid down in Schedule 1 of this rule to be conducted by the Deputy Commissioner at the beginning of each year for vacancies of the post of junior assistant likely to occur in course of the year in the respective establishment unless otherwise directed by the government in his behalf. Here, Lordship, executive deputy commissioner replaced by executive engineer because this is water resource division, executive engineer. So this notice has not been published any process. Only Lordship notice has been issued to the
No,
particular
this cadre is division wise or all divisions put together?
all divisions put together.
Where, how do you say that? From where?
That is the followed by the water resource division. They have adapted the rules, Lordship.
The cadre of junior assistant, is it based on each establishment of executive engineer or what is the name of the establishment? Huh? Division wise. So division means headed by an executive engineer. So one division headed by one executive engineer, another division headed by another. Are you sure about that? That means if LDA is to be recruited in the office of executive engineer, Silchar, division number 1, then the cadre will be confined to only that office. So a notice issued and circulated in the office of executive engineer of that division will be sufficient as per the rules. Is that your style? That is your style. All right.
So my submission will be, Lordship, there is no advertisement, only notice has been issued in the notice board, and that has been admitted by the respondent in their affidavit, private respondent in the affidavit, because government has not filed an affidavit. Private respondent has filed an affidavit that notice has been issued in the conspicuous place of the notice board.
Just a minute, Mr. Goswami, you are going very fast. This may not be very good for you. Where is the requirement for issuance of advertisement here?
Direct recruitment, Lordship. Junior assistant direct recruitment on the basis of competitive examination consisting of written test, computer proficiency test as laid down in Schedule 1 of this rule to be conducted by Deputy Commissioner at the beginning of each year for the vacancy in the post of junior assistant likely to occur in course of year in respect of establishment.
Where is the requirement of issuing advertisement?
Let me- Lordship.
The competitive exam they've held, written test they've held.
No. Lordship, as per the procedure, everywhere, Lordship, the advertisement should be in newspaper for.
Where is the requirement of issuing advertisement? That's what I'm asking you. So what is illegal about his recruitment then?
Lordship, I will give the Lordship, all advertisement in the post of LDS and other, there should be advertisement in newspaper.
Where is it?
Lordship, I will give the Lordship.
That is the only point you have, nothing
Lordship,
else.
Lordship,
If his appointment is not illegal, you don't have a case.
Lordship.
Which is the other case, other writ petition? Which is the other writ petition, Mr. Goswami?
6052, Lordship.
Has it been listed today?
Lordship.
No, you have filed another writ
So
petition.
that has not been listed. Lordship.
That is
What is the number?
We have got the filing number, Lordship, we filed it today. It has not been numbered.
Get it listed day after tomorrow along with these two matters. We'll finish up everything together because can't be done in a piecemeal manner. You have to both give a short written argument.
Yes, we will do that.
Day after tomorrow, you have the records. You heard Mr. S.K. Goswami, learned counsel appearing for the writ petitioner. Also heard Mr. R.M. Das, learned standing counsel, Water Resources Department, who submits that the records have been received by him. Mr. P. Nayak, learned standing counsel, Finance Department, Assam is present. Also heard Mr. D. Chakraborty, learned counsel appearing for the private respondent number 5. Heard in part on the request of learned counsel for the petitioner, let this matter be listed again on day after tomorrow. What is the date? At 2 p.m. as fixed part-heard matters along with WPC number so and so. Give the PC number, filing number so and so. Please give a short written argument. Your case is that his recruitment was illegal because there was no advertisement. You have to show where is the
Whether
requirement.
advertisement is necessary, whether paper publication or advertisement is necessary.
Yes. If his appointment is not illegal, then you have nothing to
Nothing
say.
to say.
If it is held to be illegal, illegal means you have to show that this is what has been done and the law prohibits this.
Lordship,
This is also possible, that is also possible, not illegal.
Lordship.
But the law governing at that point of time must prohibit this. And this is exactly what they have done, which has resulted into infringement of your right. You have a case.
Lordship,
Short of that,
Lordship. That is a
Nothing.
simple, that is a simple case.
That is the
That
simple
is a simple
case.
case.
this matter is a matter of 15 minutes.
15 minutes.
Have you also understood? Come prepared on that. I am not going to adjourn this matter on Wednesday on any ground. Whatever is your preparation level, it will be decided on that. So you want to prepare on any point, please do it in next 2 days. These matters cannot stand hanging
Lordship,
again and again.
much.
These people need to know where do they stand.
Lordship,
Our interest is to tell the litigants at the earliest with clarity
absolutely.
what is the issue. We are not interested in who wins, who loses. So please give the answers. You have the records. You will be able to answer. We will ask you what is the procedure you followed. Previous remand and reversion and all, we are not concerned. If his recruitment is found to be in accordance with law, that's the end of the matter for him. If it is not, it's the end of the matter for him. He can't claim seniority over him. That's the law. So please come prepared on this. Nothing else is there in this matters. 2 p.m. Wednesday, 2 p.m.
My lord, my
We'll
lord.
finish our other matters and. then-
Friday, Lordship, my lord, Friday.
Why? Why Friday?
Lordship, department has not filed their affidavit. till
No question on affidavit. What affidavit?
The other thing is that we have filed an RTI application where we have sought some information. That has also not been given. Lordship.
Nothing.
Without that,
Wednesday
Okay,
we'll finish
okay,
all the
Lordship.
matter.
Fine. Wednesday. Lordship.
Whatever is there on the record. we'll
Wednesday,
go by.
Wednesday.
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 Because we heard
Better,
this
Lordship.
twice and
Simple
thrice.
matter without Lordship.
Yes, what is the big deal? I told you this.
His
is a
initial
matter of-
appointment is due to the rules, then go. If
Please-
it is
please
regular.
Give me a list
we'll-
of dates.
My lord.
Both of you can do it. That's all.
Lordship.
This is what has happened. This is how he was recruited. Show the rule which violates.